Well, we may not be able to do them. Let's do those by Zoom, Ben. Call out there and tell them we're going to do them on the Zoom. So as soon as he can get them logged in, I'll start on them. But we may have to break at 9 o'clock to do the counseling center and then go back to the jail.
So Zoom, not video?
Yeah, Zoom instead of video. All right, you're Jaden Florence?
Yes, Your Honor.
All right, this is case number 23 CR 17, State of Ohio versus Jaden Florence. Florence, you were indicted on a 3-count indictment on February the 7th on a charge of theft, which alleges an honor between the period of December 15 and December 30, 2022 in this county that Tristan Nelson and you did with purpose to deprive the Yankee estate of property knowingly obtain and exert control over Massey Ferguson 165 tractor without the consent of the Yankee estate. And it was a value of over $1,000, less than $7,500. That's a 5th-degree felony. If convicted, carries a possible prison term between 6 and 12 months and a fine of $2,500. Count 2 is a charge of breaking and entering and alleges that on or about the period of December 15 through December 30, 22 in Highland County, Ohio, Tristan Nelson, you did by force, stealth, or deception knowingly trespass on the land or premises of the Yankee Farm on Short Road with purpose to commit a felony. That's a 5th-degree felony as well, carries the same penalty as count 2 or 1. Then count 3 alleges that on or about December 27, 2022 in this county, Tristan Nelson and you did receive, retain, or dispose of property belonging to a Craig Rasnick, and that having knowing or having reasonable cause believed been obtained through commission of theft offense. That is first-degree misdemeanor, carries a possible jail term of 6 months and a fine of $1,000. You're entitled to have an attorney to represent you in this matter. If you can't afford to hire one, the court will appoint one for you. And see, I see you filled your financial disclosure form out on the 9th. I don't know why is your arraignment today? You should have been arraigned a couple weeks ago, I thought. No, they set you for March 8th arraignment.
All the summonses were issued for today.
Really? From February?
Yes.
Okay. All right. Is everything on this form still correct then? You list no income.
Yes.
You list no income, you list no expenses. Now, if you didn't have any expenses, then I mean you wouldn't be here because you wouldn't be alive. You obviously have to have shelter, clothing, and food. So how's that provided?
I live with a friend at the moment.
All right, so this Spilker Road is a friend.
No, that's my mom's address. It's where I get my mail and all
Okay, well, we want to know where you live physically.
that. Okay.
What's the address?
Four 4389 US Highway 50.
US Highway 50. And that's Hillsborough?
Yes.
All right. And when's the last time you were employed, Mr. Florence?
It's been a while.
Why don't you work?
I'm trying to get a job at the moment.
Okay. Now, were you in court on this case before? Yeah, it looks
Yes.
like you were.
Yes, Your
And
Honor.
Mr. Armentrout was your attorney, all right?
Yes.
I'll appoint Mr. Armentrout then to represent you and enter a not guilty plea on your behalf in the absence of counsel. After you're done with the things that you need to do, I'll tell you about in a minute. You will need to contact his office to make an appointment to see him. All right, we'll set your first pretrial for April the 5th at 2 p.m. And you have access to a email account and a smartphone or computer?
Yes.
All right, well, we can do your pretrial hearings by Zoom. You provided information to the bailiff. So it'll be at 2 o'clock, and you'll get an email giving you a link to the Zoom that you can click on and then log in.
Okay.
Your final pretrial will be May the 3rd. That'll be also at 2 p.m. And then your jury trial will be set for June the 12th at 8 a.m. That'll be in person. You will need to sign a OR bond, which is your own recognizance. So you weren't under a bond out of municipal court, were you?
Not
No.
sure, Your Honor.
No, you're on an OR bond there. So an OR bond is your own recognizance. That means you're promising to appear at the dates and times that you're ordered to. You're going to get an assignment notice here when we get done that gives you those dates. If you fail to appear then or at any other time that a hearing is set in your case, then you could be prosecuted for an additional felony, and if convicted, sentenced on that, no matter what happens in this case. You'll be required to pay a deposit for certain statutorily required fees of $171. You'll need to make payment arrangements with the clerk to do that. You're to pay that within 30 days. You're going to be under pretrial supervision of the probation department at 117 East Main Street. Do you know where that's located?
Yes, Your Honor.
Okay. You report there as soon as you leave the courthouse today. You'll be required to report to them once a week for 4 weeks, and after that, as they determine, undergo random drug testing they may order, provide phone numbers for home, cell, and employer, have no contact with the alleged victims, have no contact with the co-defendant, Tristan Nelson. If recommended by probation, you'll be evaluated for substance abuse or mental health issues, and if any treatment is recommended, you'll enroll in and follow that during the period of this action. You'll be under house arrest at your physical residence at 4389 US 50, Hillsborough, Ohio. That means you have to be there at all times, unless you're working, going to and from work, or going to and from efforts to get a job, interviews, or filing applications, etc. You may go to and from any kind of medical appointments. You can go to any court proceedings in this or any other case. You may also attend church services or any kind of educational job training, programming, classes, GED classes, college classes, anything of that nature. Other than that, you have to be there at all times, and you'll need to notify the probation department when you're going to and from places. If you fail to comply with this bond requirement, the court could revoke that bond and have you held in court or in jail until further order of the court. So you're going to get an assignment notice, you're going to sign it, and gives you your dates and times for a court hearing. You're going to go downstairs to the clerk's office, make payment arrangements, and sign your OR bond down there, and then go directly down to probation. And then get in touch with Mr. Armentrout. And if you need his number, clerk can give it to you. You have any questions?
No, Your Honor.
All right, thank you. All right, are they ready out of the jail? You can be seated. Case number 23 CR 23, State of Ohio versus Daniel A. Miller. And you're Daniel Allen Miller?
Yes,
All right.
Your Honor.
And you're being represented by Mr. Stetina, employed Mr. Stetina?
Yes, Your Honor. Good morning.
Good morning. All right. The defendant was indicted on February the 7th on account of felonious assault, a second-degree felony. Mr. Stetina, you wish to have the indictment read?
No, Your Honor. We'll waive reading.
Okay. You've had service of it for more than 24 hours.
We have, Your Honor.
All right. And what plea is your client entering?
Not guilty.
All right. I forgot where you're from.
Well, I actually have a farm here.
I mean your office.
Oh, Columbus.
Columbus, okay. You have a farm in Highland County?
I do.
Oh, yeah, where at?
Right over next to Rick Kisling's on Divon Road.
Oh, okay. Okay. Bond will be, or I mean, I'm sorry, no, bond will be continued from municipal court. That was $10,000.
Yes,
I
sir.
believe. All right. And let me make sure we have that here. Oh, here it is. All right. Yes, $10,000 has been posted through A1 bonds. All right, so that is continued, plus the OR, which is your promise to appear. You're going to sign that downstairs in the clerk's office after we're done here. And if you fail to comply with that and appear at the times you're required, then you could have that bond revoked and be held in custody until further order of the court. You'll be required to put up a deposit of $116 within 30 days. That covers certain statutorily required fees. You'll be under pretrial supervision of the probation department at 117 East Main Street, and you're to report to them immediately after court. You know where that's located?
Yes.
All right. You'll be required to report to them once a week for 4 weeks, and after that, as they determine, under random drug testing, they may order, provide phone numbers for home cell employer, no contact with the alleged victim. If probation recommends you be evaluated for substance abuse or mental health treatment, you're to submit to that. If there's any programming recommended, you're to enroll in and follow that during the pendency of this action. And what is your address, Mr. Miller?
344 Maribel Street, Greenfield, Ohio.
Okay. And are you employed?
Yes, Your Honor.
Where do you work?
I work for Walmart.
Okay. Well, you'll be under house arrest at that residence, except you may go to and from work and go to and from any medical appointments, any court proceedings in this or any other case. You can attend any court proceedings or appointments with your attorney or probation officer in this or any other case. You can go to any kind of job training or educational programming of any sort, classes, etc. You go to church services. And do you have minor children at home?
No, Your Honor.
Okay. All right. Do you live with anyone else, or do you live alone?
Yes, I live with my girlfriend and her son.
Okay. All right. So you'll need to let the probation department know anytime you're going to be doing any of those other things, and we'll also let them know your work schedule. So after we get done here, you're going to sign your arraignment notice. Then you're going to go downstairs, sign your OR bond, and then down to the probation department.
Did you set the dates?
No, thank you. I skipped over that. The first pretrial, April 5th. Mr. Christine, you have your calendar there?
April 5th, Your Honor, for pretrial?
Yeah, afternoon.
Yeah, any time in the afternoon.
All right, so we'll set that at April the 5th at 2:30 by Zoom. I think you've done some Zoom hearings with us before, haven't you?
Yes, sir.
All right. Final pretrial, May the 3rd.
Yes, sir.
All right, that can also be by Zoom. And then the trial date, June 12th. That would be at 8 o'clock.
Time on the 3rd, Your Honor.
Pardon me?
Time on the 3rd is 2:30 as well.
Yes. And by Zoom.
June 12th is fine.
Tristan Nelson? Oh, he's here, okay. Just have a seat there. We thought. Do you have an Avalon Rich out there?
No.
Okay. Where's the ones that are in jail?
Here.
Oh, okay. Nicholas Tiller first, please. Is that okay?
All right, thank you, sir.
June 12th, and then it'll be at 8 a.m. Thank you, Mr. Stina.
Thank you.
23 CR 18, State of Ohio versus Tristan Nelson. You're Tristan Nelson.
Yes, sir.
And Mr. Nelson, you were indicted along with Jaden Florence on February the 7th on four counts. Count 1 is theft, alleges that on or about period of between December 15 and December 30, 2022 in this county, that you and Mr. Florence with purpose to deprive the Yankee estate and property unknowingly exerted control over a Ferguson Model 165 without their consent with a value of over $1,000. Count 2 alleges on about the same date you and he knowingly by force, stealth, or deception trespassed on the Yankee farm to commit a felony. Count 3 alleges on about December 27, 2022 in this county, the two of you received certain property belonging to a Craig Rasnick, knowing or have reasonable cause to believe have been obtained through commission of a theft offense. And in count 4, alleges you committed the same offense alone with on a December 24th of last year in this county, a 9600 cab Ford dual wheel tractor and other items belonging to Floyd Rhodes, over $1,000. Counts 1 and 2 and 4 are fifth-degree felonies, each of which carry a possible prison term if convicted of between 6 and 12 months and a fine of $2,500. Count 3 is a first-degree misdemeanor, carries a possible sentence in a county jail of 6 months and a fine of $1,000. Now, you are entitled to have an attorney to represent you, and if you can't afford to hire one, the court will appoint one for you. I believe this case was bound over from the grand jury from Union Court. Did you have you had an attorney there, didn't you?
Yes, sir.
Who was it?
It was she was an older lady. They said they'd have to give me another one because she don't do felony.
Yeah.
Yeah,
Huh?
Carol.
Won't rather waste time with that. All right. So, you say you're homeless, but you have an employment. Why is that?
I'm staying with a friend. Or
You list your address as 145 Homestead. That's the homeless shelter.
yeah, I haven't changed yet. That's what I was going to do today. I live over there in Courthouse.
Okay. So why didn't you put your courthouse address on there?
I haven't yet.
Okay. Well, what is it?
I'd have to ask him when I get. I just moved in there. He just helped me out.
Well, we need to know where that is
Okay.
because that's where you're going to have to live as a condition of your bond. So we'll figure it out here in a moment. But for the time being, I'll go ahead and find that you are entitled to appointed counsel. And I'll appoint Attorney Danielle Witt of Hillsborough, Ohio, to represent you. And in the absence of counsel, I'll enter a not guilty plea on your behalf. Give me the dates for the, Dan, did you write down the dates I had for Mr. Florence?
Yes, 4-5 and 5-3,
Okay.
and 6-12 for the trial.
4-5, 5-3.
Both at 2 o'clock. 6-12 for the trial.
All right. Your first pretrial is going to be April the 5th at 2 o'clock. If you have access to a computer or a smartphone, an email, we can do a Zoom hearing.
Yes,
If not, it'll be in person. Those will be April 5th and May the 3rd, both at 2 o'clock. And on June the 12th, there will be your trial date. That'll be in person here. You're released on bond, the same bond from municipal court. I'll check and see what that was here. What's your bond out of municipal court? Did you have to post a bond, or did you get released on your OR?
OR bond?
All right, so it'll be OR only, which is your promise to appear. Fail to appear, you could be prosecuted for an additional felony, and if convicted, sentenced on that, no matter what happens in this case, you'll be required to pay service fees of $171 within 30 days. You'll be under pretrial supervision of the probation department at 117 East Main Street. You report there immediately upon completion of this hearing. You report once a week to them for 4 weeks, and after that, as they determine, undergo random drug testing they may order. Provide phone numbers for home cell employer. Have no contact with alleged victim. Have no contact with the co-defendant, Jaden Florence. If recommended by probation, you'll be evaluated for substance abuse or mental health issues. If any treatment's indicated, you enroll in and follow that during pendency of this action. You'll also be under house arrest at your residence. You say that's in Washington Courthouse?
Yes, sir.
All right. You will have to be there at all times unless you're working, going to and from work, medical appointments, court proceedings in this or any other case, appointments with an attorney or probation officer in this or any other case, any kind of schooling, job training, educational programming, or church services. Other than that, you have to be here at all times, and if you fail to comply with that, then that bond can be revoked, and you can be held until further order of the court. Do you have any questions?
Yes, sir.
All right. I'm going to come around to the over here to the desk and get your assignment notice signed and fill out your information on your email. Also, you're going to go to the clerk, then to the probation department.
Your Honor, some of these, the credit when asked about fingerprints and photos of the sheriff's office.
Well, he's bound over. He'd been charged already. I know he has been. Yeah, the first two have. That's why I didn't ask him. Versus Nicholas Tillard. Mr. Tillard, looks like you were indicted by the grand jury on a charge of endangering children and domestic violence. Count one alleges that occurred before about December 10, 2022 in this county. And that you, being a parent, guardian, custodian, or person of control or custody, or local apprentice over CT who was under 18, 2 years, was actually 2 years of age, created a substantial risk of physical harm to the health or safety of that child. By violating the duty of care or protection or support, you've been previously convicted of endangering children in a Hillsborough Municipal Court. That's a fourth-degree felony, carries a possible prison term, convicted between 6 and 18 months, and a fine of $5,000. Also alleges on December 10, 2022, you knowingly caused or attempted to cause physical harm to family member Heather Hyatt. It's a first-degree misdemeanor, carries possible jail term of up to 6 months and a fine of $1,000. Now, you're entitled to have an attorney to represent you in this matter, and if you can't afford to hire an attorney, the court will appoint one for you. And I see you filled out an affidavit or a financial disclosure form. Everything on this form correct? Okay. Well, I see a couple things are incorrect. You list Heather Hyatt and Jake Tillard and several others as living with you, and that's not going to be happening while this case is pending. But in other words, but everything else is correct. All right. Now, who was your attorney at the municipal court in this case?
Catherine Hatton.
All right. The court will appoint Catherine Hapner to represent you. In the absence of counsel, I'll enter a not guilty plea on your behalf. All right, okay, where is it? All right, now I can't find the arraignment entry. Ben, do you have the arraignment entries out on these? Oh, okay, no wonder I couldn't find it. Hmm?
Should be in your file there, in your checks.
Well, this is a cluster. All right. So the court appoints Catherine Hapner to represent you. In the absence of counsel, I'll enter a not guilty plea on your behalf. Set your first pretrial for March the 22nd at 1 p.m. Final pretrial, whoops, I'm sorry. We're going to have a bond review hearing on your case on Thursday morning, which will be the 10th at 8:30 a.m. And that'll be by Zoom. Huh? Oh, I'm sorry, Friday's the 10th. Friday the 10th, not Thursday, thank you. At 8:30 a.m. Final pretrial will be April the 5th at 1 p.m. And trial date will be April 27 at 8 a.m. Bond will be set in this matter in the amount of $10,000 plus your own recognizance, which is your promise to appear. If you fail to appear, you can be prosecuted for an additional felony, and if convicted, sentenced on that, no matter what happens in this case, will be required to pay a service fee of $171 for certain statutory required fees within 30 days. You'll be required to be under pretrial supervision of probation if you make bond at 117 East Main Street. Report to them immediately upon your release. Report to them once a week for 4 weeks. And after that, as they determine, undergo random drug testing. They may order, provide phone numbers for home, cell, and employer. Have no contact with the alleged victims or any family. That includes everybody that's listed on your financial disclosure form. If recommended by probation, you'll be evaluated for substance abuse or mental health issues. If any treatment's indicated, you're to enroll in and complete that during the pendency of this action. You'll be under house arrest at your residence, which will have to be somewhere other than the address that the alleged victims are living at. And you'll have to be there at all times unless you're working, going to and from work, medical appointments, court proceedings in this or any other case. You can attend meetings with probation officers and attorneys in this or any other case. You can also attend any kind of church services, job training, educational programming, college classes, anything like that. And I'll also indicate to you that when I say no contact, that means no contact in any way, shape, or form, not directly, not indirectly, not through other people, not by any means whatsoever. And if you violate that order, that could result, any of those orders in your bail could result in your being taken back into custody and having that bond revoked until further order of the court. Do you have any questions? All right, thank you. All right, I see that Mr. Holland is on the screen. All right, this is case number 22 CR 214, State of Ohio versus Kyle A. Holland. You're Kyle A. Holland appearing there from Counseling Center on the Felicia Snyder screen.
Yes, Your Honor.
All right. This hearing is being conducted by Zoom. His attorney is William Arment-Trout, appearing from his office. Appearing from the prosecutor's office is Prosecutor Collins. Prosecutor Collins, if you could activate your video and turn on your mic. Thank you. All right, Mr. Armentrout, you and your client both agree to waive your client's physical presence in the courtroom and agree this matter be conducted by Zoom? And you're all right with that, Mr. Holland?
Yes, Your Honor.
All right, Mr. Holland's been convicted by a plea of aggravated possession of a fentanyl-related compound, a fourth-degree felony under 2925.11 of the Ohio Revised Code. The court ordered pre-sentence investigation. I've received that report and reviewed it. Have each of the attorneys received a summary? All right. Anything from the state?
Only what's contained in the
All right. Excuse me. Thank you. Armentrout.
We have some replacement on community control here. It's obviously still in treatment. That was a recommendation from the state of Ohio. I believe the PSI said this was the first felony. We'd ask the court to.
All right. Mr. Holland, anything you would like to say?
No, Your Honor.
All right. So you order the court to defendant be sentenced to a term of 3 years of community control under the following conditions. You'll be under the probation department supervision. You'll be required to obey all laws and conduct yourself in a law-abiding manner at all times. Report when and as directed. Be honest in any answers you give to them regarding the conditions. You'll be required to keep them informed of the residence, place, and employment at all times. May not change either without prior permission. May not leave the state of Ohio at any time without prior written permission. You may not enter upon the grounds of any correctional facility, nor may communicate with or attempt to communicate with anyone who's an inmate or prisoner in those facilities without prior permission. You may not purchase, possess, own, use, or have under your control any kind of a firearm, ammunition, dangerous ordnance, weapon of any other type. It's a violation of both federal and state law for you to do that because of your conviction. You may not purchase, possess, use, or have under your control. You cannot have any of those things on as a condition either, I should say. You may not purchase, possess, own, use, or have under your control controlled substance, drug of abuse, CBD, oil, kratom, or any variant or analog of any controlled substance that has effects similar to controlled substances or drugs of abuse, or any instrument, device, or thing that may be used to administer drugs, prepare them for administration, unless you have a lawful prescription, a copy of which you must have within 24 hours of receipt, provided, I should say. You must also submit to drug testing when and as directed. You may not purchase, possess, use, or have under control any alcoholic beverage, or be in places where the sold being consumed even if otherwise lawful. Not to associate with any co-defendants in this case or any other person with a criminal record, member of a gang, any other criminal group, or any person who has in the past or could in the future influence you to commit a crime or violate these conditions, and applies to any family members who are living with you, unless you were living with them immediately before the commission of this offense. You may not, after the date of this order, marry or establish cohabitation or common law marriage type relationship with another without written permission. You must report any contact with law enforcement or any arrest, citation, conviction, or other charge of violating the law not later than the next business day after that occurs. You must provide your supervising officer financial information records so your ability to pay restitution fees or costs can be reviewed. If you're referred for any further programming by probation for evaluation assessment, you'll submit to that. If there's any programming recommended, you enroll in and successfully complete that. You'll be required to pay the court costs of this action, make payment arrangements to do that. You'll be required to do 400 hours of community service at a rate of 20 hours per week for 20 consecutive weeks unless you're employed at least 20 hours a week, a full-time student, or you have documentation from a physician or prior disability finding you're unable to do that. You'll be required to successfully complete the substance use disorder treatment and aftercare at counseling center. Now, by being placed on community control, you're deemed to have consented to a search without a warrant of your residence, your person, residence, vehicles owned by you or used by you, or any other property or place that is under your control or where you're found at any time by any officer of the probation department. There will be no fine or driving suspension imposed. You will pay the court costs, and you do make arrangements as one of your conditions. If you don't do that, the clerk can also collect that through various means, including levying on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then the court can order you to do additional community service beyond that already ordered by the court, and give you credit for an hourly rate set by the court for each hour you work, and each hour you work will reduce that until paid in full. Now, in the event that it's alleged that you have failed to comply with these conditions, the probation department will file a written notice of that with the court. You'll be given a copy. You'll have a hearing. You'll be entitled to have an attorney. If the outcome of that hearing is that you have failed to comply, then the probation will be revoked, and you could be sentenced to a term of between 6 and 18 months and fined $5,000. If that happens, once you complete the prison term, the Adult Parole Authority may, as part of this sentence, put you under post-release control supervision for up to 2 years. If they do, you'll be supervised on the terms they set, and if during that period of time you feel that you have failed to comply, they can return you to prison, even though you serve the entire prison term set by the court, for an additional period of 1 year, whatever time is left on the probation period, whatever is greater. If that occurs, that must be served consecutively to the sentence in the new case. All right. Is there anything further from counsel?
No, Your Honor.
All right.
No, Your Honor.
All right. You're complete with your case now, Mr. Holland. You're no longer under pretrial supervision. You're under the new conditions. Probation department will get in touch with you, and your supervision will be transferred to a felony officer. All right. Thank you. All right. Now, Miss. Now, Mr. Gibson had been at the counseling center, so this was scheduled for a hearing by Zoom, but I have received a fax yesterday from probation indicating that Mr. Gibson left the counseling center on March the 5th and did not contact the probation department, nor has he reported to jail. Mr. Arjim, have you had any other information regarding Mr. Gibson?
No, Your Honor.
Okay.
We have not heard.
And I assume you have not either, Ms. Hapner?
No, Your Honor, I did receive that notification on Monday, and I've not been able to get in touch with him since
All right.
then.
Well, the court will also note, take judicial notice of the fact that it's a violation of his bond. On February the 13th, we filed the order allowing him to go there on his OR on the condition that he remain there until further order of the court, and he has violated that. So CAPES will order for his arrest. Thank you. And Mr. Martin, I think, is over here when you can come over to Ms. Hapner.
Okay, I'll be there momentarily.
CR 42, State of Ohio versus John Nicely. Mr. Nicely is being arraigned. You were indicted yesterday, Mr. Nicely, for violating a protection order consent agreement that alleges that on or about June 28, 2022, you recklessly violated a term of protection order or consent agreement approved under 29-20-26 or 31-13-31 in the Clinton County Common Police Court. Case 18-000029 on February 7, 2018, and you had previously been convicted of violating that statute on April 26, 2018 in Hillsborough Municipal Court. So that is a 5th-degree felony that carries a possible prison term if convicted of 6 to 12 months and a fine of $2,500. Now, look in here. You have a right to have an attorney to represent you. If you can't afford to hire an attorney, the court will appoint one for you. I see that you have filled out a financial disclosure form, which lists that you're living with your mother. Then other than that, it lists nothing else. So do you have any income?
Not this time, Your Honor.
When was the last time you were employed?
Prior to coming to incarceration.
And where was that?
Dunsea's construction.
Okay. All right. Court then will find that you are entitled to appointed counsel. And who was your attorney in the municipal court?
Dennis Kirk.
All right. Court will appoint Mr. Kirk to represent you, enter a not guilty plea on your behalf. We'll set a bond review hearing for your case on Friday morning, the 10th at 8:30 by Zoom. Your first pretrial will be March the 22nd at 1 p.m. Your final pretrial will be April the 5th at 1 p.m. Your trial will be set for April 24 at 8 a.m. Court will set bond in the amount of $10,000 plus your own recognizance, which is your promise to appear. And if you fail to appear, then you could be prosecuted for an additional felony. And if convicted, sentenced on that, no matter what happens in this case. You'll also be required to pay a deposit prior to release of $171 to cover certain statutorily required fees. If you do make bond, you'll be under pretrial supervision of the probation department at 117 East Main Street. You report there immediately upon release, and then once a week for 4 weeks, and after that, as they determine, undergo random drug testing they may order, provide phone numbers for home, cell, and employer, have no contact with the alleged victim or any family member, and that means no contact, not only in person, but by phone, email, social media, postings, any kind of contact. It also means you cannot have someone else contact that person, and it also means if that person reaches out to you, you're not to contact them because they cannot waive this right. You're recommended by probation. You'll be evaluated for substance abuse or mental health issues, and any treatments indicated. You enroll in and follow that during the pendency of this action. You'll also be under house arrest at your residence, meaning you have to be there at all times, unless you're working, going to and from work, medical appointments, court proceedings in this or any other case, appointments with an attorney or probation officer in this or any other case, attend church services, and also any kind of educational programming, GED classes, college classes, job training, anything of that nature. If you violate any of these conditions, then the bond can be revoked, and you can be held until further order of the court. You have any questions?
Yes, sir.
All right, we'll have your Zoom bond review Friday morning. Thank you.
Thank you, Your Honor. Have a good day.
You were indicted by the grand jury on yesterday for 2 counts of misuse of a credit card, 1 count of receiving stolen property. Count 1 alleges that this happened between November 1, November 10, 2022 in Highland County. And in count 1 and 2 alleges you had a purpose to defraud, used a credit card through 1 or more transactions, knowing it had been used unlawfully, and the victim was an elderly person, and it was used in a 90-day consecutive period. And alleged victim or card there is a Chase Bank card. Count 2 is the same offense, except it says it was a Lowe's card. Loss in that case being over $1,000, less than $7,500. And count 3 alleges that on or about November 1 through December 2022, in this county, received, retained, disposed of property of a Stephen Brooks, which was a credit card, knowing or having reasonable cause to believe it had been obtained through the commission of theft offense. Count 1 is a 5th-degree felony, carries possible prison term convicted between 6 and 12 months, fine of $2,500. Count 2 is a 4th-degree felony, possible prison term between 6 and 18 months, fine of $5,000. Count 3 is receiving stolen property, or is a 5th-degree felony as well, the same as count 1. Now, you're entitled to have an attorney to represent you. If you can't afford to hire an attorney, court will appoint one for you. And I see that you've listed on your disclosure form that you're self-employed and making about $2,500 a month. Is that correct?
Yes, sir.
All right. Well, since you're incarcerated, a court will find that you are not able to hire your own counsel. Court appoints Attorney Danielle Witt of Hillsborough, Ohio, to represent you. In the absence of counsel, I'll enter a not guilty plea on your behalf. We will have a bail review hearing for you on Friday morning at 8:30. That'll be by Zoom. Your first pretrial will be March the 22nd at 1 o'clock p.m. Your final pretrial will be April the 5th at 1 o'clock p.m. Trial date will be April the 27th at 8 o'clock a.m. Do you have any previous felony convictions?
No, Your Honor.
All right. Are you being held in jail on this charge, or this case only?
No, Your Honor.
What are you being held for?
TPO violation.
Okay.
Your Honor, I believe that he is doing municipal court time for probation violation. He had 100 and some days imposed.
Okay. Well, in this case, since he has no previous felony conviction, the bond will be an OR only. So once you get done with your time on that, if this case hasn't been resolved, you'll be released on your own recognizance, which is your promise to appear. You will have to, and if you fail to comply with that, then you could be prosecuted for an additional felony, and if convicted, sentenced on that, no matter what happens in this case, you will have to pay a deposit within 30 days of $171 to the clerk for statutorily required fees. You'll be on a pretrial supervision probation, 117 East Main Street. You report them immediately upon your release, once a week for 4 weeks after that. Undergo random drug testing in the order, provide phone numbers for home, cell, and employer, have no contact of any kind, directly or indirectly, with any victim or family member of any victim. If recommended by probation, you'll be evaluated for substance abuse or mental health issues. If any treatment's indicated, you'll enroll in and follow that during the pendency of this action. And you'll be under house arrest at your residence, meaning you have to be there at all times unless you're working, going to and from work, medical appointments, court proceedings in this or any other case. You can also do any kind of job training, educational programming, attend any kind of church services that you may belong to. And your residence is at 9697 US 68 South, is that correct?
That's where the victim's address was. That's where I was currently.
Okay, so you'll have to be determined that. You have to get an address to give to the probation once you, if you're released while this case is pending.
Okay.
All right, do you have any questions?
No, Your Honor.
All right, thank you.
Thank you, sir.
All right, are you David Bennett?
Yes, sir.
Case number 2340, CR 47, State of Ohio versus David Allen Bennett. Mr. Bennett's appearing from the Justice Center. You were indicted by the grand jury yesterday, Mr. Bennett, on aggravated possession of methamphetamine. Alleges that occurred on about 11/4/2022 in Highland County, that you knowingly obtained or used methamphetamine in an amount over bulk less than 5 times bulk. That's a third-degree felony, carries a possible prison term of between 9 and 36 months and a fine of $10,000, a possible license suspension of 6 months to 5 years. You're entitled to have an attorney to represent you, and if you do not have the funds to hire one, the court will appoint one for you. See, you filled out a financial disclosure form. Is everything on this correct, Mr. Bennett?
Yes, sir.
When's the last time you were employed?
I think 2017, I believe.
Okay. All right, then the court finds that you're entitled to appointed counsel. I'll appoint attorney Barger to represent you. Actually, Ms. Barger, if you go ahead and log on, we can go ahead and get his bond set. We won't have to have a bond review hearing on Friday morning. I know you're at a disadvantage, but once you talk with him, if you wish to file any further action on that, we can handle that. And Ms. Collins is present as well, so we can go ahead and have that part of the hearing. So, you assume your client enters a not guilty plea? Yeah. All right. Now, the court will set the first pretrial in this case for, excuse me, March the 22nd at 1:30 p.m. Final pretrial will be April the 5th, 1:30 p.m. And trial will be set for April 24 at 8 a.m. All right, now regarding bond, Ms. Collins, on behalf of the state.
Your Honor, I don't have this file in front of me, so I'm not sure what Mr. Bennett's prior criminal history is, but I will tell you that I was in county court with him a couple weeks ago. He was there for domestic violence charge against his mom, and I asked the court not to give him a bond in that case. They did. He failed to appear at the very next hearing. There was a KPS issue, and we had to go find him. His brother is Keith Bennett, who also had voters to appear for him. We picked him up at the same time. He was at his house. So his very recent history is that if you lower his bond or give him an OR, he will not appear.
All right, Ms. Barger.
Can't hear you.
Yeah.
Your Honor, having just been appointed and having met with Mr. Bennett, unfortunately, I can't give much information. However, it does sound like he does have a motion to stay. He is clearly in it.
All right. Well, for the time being, the court's going to set bond the amount of $10,000 plus OR, which is your promise to appear. If you fail to appear, Mr. Bennett, you'll be prosecuted for an additional felony and if convicted, sentenced on that no matter what happens in this case. You'll also be under pretrial supervision of Probation Department 117 East Main Street. You'll report to them immediately upon your release, should you be released, once a week for 4 weeks, and after that, as they determine, undergo random drug testing, provide phone numbers for home, cell, and employer. If recommended by probation, be evaluated for substance abuse, mental health issues, any treatments indicated, enroll in and follow that during the pendency of this action. And you'll be under house arrest at your residence, meaning you have to be there at all times unless you're working, going to and from work, medical appointments, court proceedings in this or any other case, appointment with an attorney, probation officer in this or any other case, attend any kind of job, training, schooling, classes of any sort, educational classes of any sort, or church. Other than that, you have to be there at all times. If you fail to appear, that could be basis for your, fail to comply, it could be basis for your bond being revoked and being held till further order of the court. And again, your attorney, once she meets with you, if she wishes to file something else for me to review it further, we will do it at that time. All right, thank you.
Can I say something, Your Honor?
No, you can talk to your attorney when she talks with you.
You need to call a straight line to you.
I just said no. You just go back to your cell and she'll be in touch with you. All right. All right, Rebecca Steinmetz, please. Again, I don't know why they did that. Okay. No, Steinmetz. I'd get them in a breakout room.
Excuse me.
Brenda Steinmetz appearing there from the jail.
Yes, Your Honor.
All right, this is a Zoom hearing for sentencing. The defendant's attorney is Sarah Barger, appearing from her office, appearing from the prosecutor's office is Prosecuting Attorney Collins. And Ms. Barger indicated that she wants to have a breakout session with you, Ms. Steinmetz, so I'm going to put the two of you into a breakout room, and then the deputy will step out of the room during that, and you and she will be able to talk without anyone else seeing you or hearing you. And then when you're done, well, when I sign this here just momentarily, there's going to be a button pop up that says join breakout room. Click on that button, and then when you're done, you'll click leave, and then you'll have to join back in to the meeting. And then I'm going to go ahead and have another hearing here while you guys are in that breakout room, and so I won't be able to get you back in immediately, I don't think, but as soon as I'm done with the other hearing, we'll get back to you.
Thank you, Your Honor.
All right, so should be popping up on your screen.
Yes, sir.
Recording stopped.
All right. State of Ohio versus Sean Michael Howell. Appearing on behalf of the state is Assistant Prosecutor King. Appearing on behalf of the defendant is Attorney Jacob Wagner. And you are Sean Howland?
Yes, sir.
All right. Mr. Howland has entered pleas of guilty to a plea of guilty to aggravated trafficking methamphetamine, a third-degree felony. Court ordered pre-sentence report. I've reviewed that. Have each of the attorneys had an opportunity to review a summary?
State has, Your Honor.
Defense counsel has, Your Honor.
All right. Anything from the state regarding sentencing?
Only was contained in the plea agreement, Your Honor, and the restitution in this case is $240 to the task force. Thank you.
Mr. Wagner?
Sean, go ahead and stand up. Your Honor, we'd ask the court to go along with the recommendation. Like I said, I'm looking at Sean's discovery, the PSI, it appears this is the first criminal history. Obviously, he picked the wrong avenue to go in for his first crime, being the fact that some of these were high-level F2s, Your Honor. We just ask the court to go along with the recommendation. We'll file a judicial release when the appropriate time comes.
Mr. Allen, anything you'd like to say? It's the order and judgment of the court, you be and are hereby sentenced to the Correctional Reception Center in Ohio for a period of 24 months. Let's see. Oh, here they are. We have new jail time credit forms that we just got this morning. And I don't have one for him. Oh, we got the old one. Yeah. Okay. All right. So it looks like you were in jail for 2 days from December 7th to the 9th. All right. So you get 2 days of jail time credit. Now, upon completion of this time, of this term, the Adult Parole Authority has the right under the law to put you under post-release control up to 2 years. That means you'll be supervised by a parole officer, and if they determine that you have failed to comply, they can return you to prison, even though you serve the entire term set by the court for an additional period of up to 9 months for a single violation, up to a maximum of half of your prison term, which is 12 months for all violations. However, should you commit a new felony while under post-release control, then in addition to whatever sentence the judge in the new case can impose upon you, that judge could also sentence you, in this case, to an additional period for committing that offense while under post-release control in this case, to an additional period of a year, whatever time's left on that period of post-release control, whichever is greater. If that occurs, that has to be served consecutively to the sentence in the new case. It's also ordered that you pay restitution to the Highland County Task Force in the amount of $240 payable through the Highland County Victim Witness Restitution Office, and that you'll pay any service fees connected with that service. You're also ordered to pay the court costs, which judgment, grant, and execution is ordered. If you fail to pay those or make payment arrangements, then the clerk can collect that through various means, including levying on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then upon completion of your prison term, not while in prison, the court could allow you to do community service, give you credit for each hour you worked, and an hourly rate set by the court, and each hour you work will reduce your judgment by that amount until paid in full. All right, is there anything further in counsel?
Just the mandatory fine, Your Honor.
Oh, okay. Has there been any change in your circumstances since I appointed Mr. Wagner to represent you? All right, then the mandatory fine is waived. Thank you. All right, you're remanded to custody. All right, case number 22 CR 225, State of Ohio versus Fernando Trevino Jr. And you are Fernando Trevino Jr.?
Yes, sir.
All right. The state is represented by Assistant Prosecutor King. Defendant is represented by Attorney William Armentrout. And the defendant has entered a plea of guilty to failure to comply with the order of signal police officer, a third-degree felony. Court ordered a pre-sentence report. I've reviewed that. Have each of the attorneys had an opportunity to review a summary?
No, Your Honor, I don't believe it.
Oh, actually, we didn't order one in this case, did we?
No.
That's right. No, I'm sorry. Habit. All right. I was wondering why it wasn't in the file. All right. Mr. King, anything on behalf of the state?
Only what is contained in the plea agreement, Your Honor, and the restitution in this case is $299.72 to Michael Everhart.
Mr. Armentrout?
Stand up. Your Honor, I would ask the court to follow a recommendation in the plea agreement that we a sentence of 12 months, I believe. The restitution may have been paid. There may have been some court costs that have been paid. I'm not sure. As the court's aware, Mr. Trevino had made a bond. He lives in Indianapolis, and he hasn't failed to appear for pretrial supervision, and he's here today. If the court does impose the sentence as agreed upon, he would ask for an additional 48 days to finish tidying up. I'm sorry? 48 hours, Your Honor. He's had time. He just didn't get everything finished that he needed to. I guess, to his credit, he could have not shown up today, and he has from Indianapolis. So we'd ask the court to consider that.
Mr. Trevino, you have anything you'd like to say?
No, sir. I'm in the court's mercy if I please get any little time, because I do live in Indianapolis, and I got my dogs. I have 3 King Corso puppies, and I have my house. And when I was in jail, it was broken into, so they tore everything up. So when I come back home, it was all in there. They came in and ransacked and spray painted my house, windows. They took my stove, oven, refrigerator, soda in, cut pipes and this. So I've been trying to piece my house back together, and I have these dogs. So I'm trying to sit there and find the right people so I can put somebody in my house while I go do this time that I can trust, so my house won't be tore up anymore. So at least I'll have a house to go to when I do finish doing this sentence. So I please ask the courts if they consider granting me this. I know I live far away, and you guys thought that I wasn't ever going to come back and everything. The prosecutor said it, you said it, but I've shown you numerous times I've come back, time after time after time. I've been in contact with the probation officer. I've been in contact with Mr. Armentrout. I've been in contact with the clerks and everybody. I've called everybody. I try to call them every day, every other day, just to tell them everything's all right. I'm trying to, do the right thing. So I'm just asking the court to please consider that. And I promise you, I will be back. If not, I don't want to get in no trouble, no how. I'm sorry I got in this chase right here. I've been out of trouble. I ain't been doing nothing. I come up here. My mom just passed, so I try to help my dad. And turn against me. I'm just asking the court's please consider this. Because the time, I'm going through the time, that I don't lose my house. I was in jail 70 days. And tore the whole house up. Tore everything up.
All right, well, there's a agreed sentence of 12 months. You were in court on February the 10th, and I believe you've been out of jail before that. Actually, it's February the 9th. And if all these things that you've told me are true, it's very unfortunate, and I'm sorry for that. But quite honestly, I don't want to test the temptation any longer.
I promise you.
You be quiet. Okay, you had your talk.
My fault.
Now it's my time.
Sorry.
And when I speak, you don't. Now, I'm a dog lover, have dogs of my own. Should have had that taken care of. You don't drive 165 miles from Indianapolis to a court knowing you're going to be sentenced to prison and not make arrangements for your animals. And if you're that uncaring about your animals, then you need to make a collect call from the jail to somebody to ask them to take care of them. And if your house was broken into while you were gone and this damage was done, unfortunately, maybe that's going to happen again. A couple of more days isn't going to make any difference. So it's the order of the court that you be and are hereby sentenced to the Correction Reception Center at Orient, Ohio for a period of 12 months. And according to the sheriff's here, you have 69 days of jail time credits. You were arrested on 10/29. You've been out of custody since 5/23 of 22. So that's almost 9 months you've had to get your affairs in order. Now, upon completion of that prison term, it is mandatory that you be under post-release control supervision of the Adult Parole Authority for 2 years. Wait a minute. I'm sorry, 1 year and a maximum of 3. They just changed it. And that means you'll be supervised on the terms they set. If they determine that you have failed to comply, they can return you to prison to make you serve an additional period of up to 9 months, or in this case, 6 months for any single violation or multiple violations. However, if you commit a new felony, then the judge in that new case could sentence you to an additional period, in this case of 1 year, whatever time's left on that period of post-release control, whichever is greater, for committing that offense while under post-release control in this case. And if that occurs, that's served consecutively the sentence in the new case. You're also ordered to pay restitution, the amount of $299.17 to Michael Everhart, or 72 cents, to Michael Everhart through the Hyden County Victim Witness Escrow account, and pay any service fee charged with that. If it's been paid, then just provide proof of that to them. Now, you're also have your license suspended for 3 years, beginning today. That's a mandatory sentence. Now, once you complete your sentence, if you have proof of insurance and you are otherwise legal to drive, then the court will grant you limited driving privileges once you provide that proof to the court. Now, you're also ordered to pay the court cost, and if you don't do that, then the clerk can collect that through various means, including levying on bank accounts, wages, or any other assets you may have. If that doesn't collect it, then the court will allow you to do community service once you complete your prison term in this court and in this county, and give you credit for each hour you work in an hourly rate set by the court. Each hour you work will reduce your judgment by that amount until paid in full. And I believe that's it. Anything further from counsel?
No, Your Honor.
All right, you're remanded in custody, Mr. Trevino.
It's done.
All right, this is case number 23-CR-008, State of Ohio versus Brenda Ann Steinmetz. And you're Brenda Steinmetz appearing from the jail, correct? All right. And her attorney is Sarah Barger, and representing the state's prosecutor Collins. They're both appearing by Zoom. Ms. Barger, you and your client both in agreement that this hearing can be conducted by Zoom rather than in person?
Yes,
And you're okay with that, Ms. Steinmetz?
Yes, Your Honor.
All right. The defendant has entered a plea of guilty to aggravated possession of methamphetamine, a fifth-degree felony. The matter was referred for a pre-sentence report. The court has reviewed that. Have each of the attorneys had an opportunity to review a summary?
The state has, Your Honor.
Yes, please.
All right. Anything from the state?
Only what's contained in the plea agreement, Your Honor.
All right. Ms. Barger?
What is contained in the plea agreement, Your Honor? My client has advised me there is something she would like to say to the
I'm sorry, I couldn't hear you.
My client has advised me there is something she would like to say to the court. She would like to.
All right. Oh, sure. All right. All right, Ms. Steinmetz, anything you would like to say?
Yes, sir. Dear Honorable Judge Paul, I would like to start by apologizing for my poor choices that has brought me before you. I would also like to ask you for this opportunity to better myself. I know I don't have a pretty past, mainly due to drug addiction. I also know my past with APA is not acceptable. I feel I was never given a fair chance at a program when I addressed my drug problem to my APA officers. I've tried to improve my life by moving away from people and substances. I was actually sober for 6 months till the day I got arrested, which I went to the town I fight my addiction only to see my daughter, but ended up setting myself up for failure because I relapsed in the process of trying to go see her. Due to being high, I came to jail. I don't want to only look at this as being a punishment, but also as a chance at a sober life. I really would like to prove not only to the courts and you, but also to myself and my kids that I do want to change and learn to cope with my addiction rather than run from it. So I'm asking you to please give me this only chance to save myself and show my addiction I'm stronger than it. Thank you.
Anything else, Ms. Barger? All right. Well, did you write that speech yourself, Ms. Steinmetz?
Yes, I did, Your Honor.
All right. Well, it's very well written, and you can tell you've got a lot of experience at this type of thing, because your description of your past night being pretty is a very major understatement. I see you have 3 prior felony convictions, and you're still on PRC. And you've had previous drug treatment in the Monday program in 2019, which you successfully completed. You got out of prison on 9/13/20, and 10 days after that you were arrested for threats against the father of your child and your stepmother and your stepsister. And you admitted to having narcotics inside your body when you arrived at the jail. You were given the opportunity to complete the Sojourner program by the APA. On 11/2/20, you were arrested for failing to comply with the EMU requirements by not keeping it charged. You were given a sanction for that. 12/17, and a warrant for another instance where you didn't charge your EMU, and arrested on 2/8/21. Went to Pathways, a halfway house in Cincinnati on 2/17, absconded the same day. Warrant again in March, arrested on that, sanctioned to the jail, ordered to report to APA, didn't do that. Warrant issued, arrested in July on that warrant. Back to Pathways halfway house in Cincinnati, and surprise, surprise, walked away the same day, apparently out the back door. Another warrant issued, arrested in this county, got a unit level sanction, then arrested again for other charges in this county, APA holder, sanctioned, released back to PRC on 6/29, on 8/9 of absconder. Before the warrant was issued, the sheriff got you on a failure to appear on a mini court case, and now you're here. You've just had time after time opportunity to do something. The report from the prison on your incarcerations is about 3 pages, well, 2 full pages of notes, a number of which show various violations, including disrespect, disobedience, false information, numerous disobediences, threatening others. It's pretty clear to me that your problem is much more than drugs. It's your attitude. And blaming everything on the drugs, the drugs are part of your problem, but they are not the main problem. The problem is your attitude. So the court does not feel that you are amenable to community control, given your history on supervision of the APA is abysmal, and I think there's no reason for the state of Ohio to waste any more resources on you when you're clearly not going to make use of them. So it's a judgment in order of the court that you be sentenced to the Ohio State Reformatory for Women in Marysville, Ohio, for a period of 8 months. It's also ordered that the PRC time that you have remaining, and I know I looked at that yesterday. At one point it was 464 days, but I believe it's less than that now. Well, we'll find it. Whatever it is ordered to be, it's either 1 year or whatever time was left on the post-release control, whichever is greater. Miss Collins, you happen to have that in your file?
I was trying to add it up quickly, but it was 507 days as of January the 12th.
507?
Yes.
All right, so that was on January the 12th, so that means 19 in January, 28 February. Today is the 8th, so that would be 16 and 9 is 25. That would be 55 days off of 507, 452 days. So 452 days is imposed, and that is ordered to be served consecutively as required by law to your sentence. Now, jail time credit. Is this an old one or new one? All right. Well, I don't have it. I don't know. Maybe you can find it in there. That's not a very good way to do things, but I guess we'll just have to adapt. It looks like you were arrested on January 10th, is that correct?
It was actually, I was arrested September 1st. I did 6 months here.
Well,
This indictment, I got served with this indictment January 10th, yes.
all right, so you weren't arrested on this indictment until the 10th, all right. So you get credit since from January the 10th. Well, actually, I don't know if she was in jail on this charge alone after that. Yeah, I guess she was, all right. So from January the 10th, so that'll be 21, 28 days in February, that's 49, and 8 today is 57 days. It's 57 days of jail time credit. Now, upon completion of your prison term, it is possible that the Adult Parole Authority will put you on post-release control for a period of up to 2 years. They don't have to, but if they do, you'll be supervised under the terms they set. If during that period of time they find that you have failed to comply, they can return you to prison, make you serve an additional period of up to, in this case, half of the prison term for one or more violations. However, if your violation is a new felony, then in addition to whatever sentence the judge can impose in the new case, the judge could also sentence you for committing an offense while in under post-release control in this case to an additional period of a year, whatever time's left on that, whichever is greater. If that is the case, that is required to be served consecutively. You also will repay the court costs as judgment, grant, and execution is ordered. If you fail to do that, then the clerk can collect that through various means, including levying on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then upon completion of the prison term, not while you're in prison, you can do community service as credit. In this county, be given credit for each hour you work in an hourly rate set by the court each hour you work. Reduce your judgment by that amount until paid in full. All right, is there anything further to counsel?
No, Your Honor.
All right, you're remanded back to custody. All right, that completes.
Can I talk to my attorney? I need to ask him my discovery packet.
All right.
Ms. Barger, can I get my discovery packet?
Should already have.
Two CR 224, State of Ohio versus Wade Anthony Page. Present for the state is Assistant Prosecuting Attorney King. Present on behalf of the defendant is Attorney Jacob Wagner. And you're Wade Allen Page? Okay. Mr. Page has entered pleas of guilty to 3 or 4 counts. Count 1 is aggravated assault. Count 2 is felonious assault. Count 3 is failure to comply. And count 4 was a forfeiture of a shotgun and a Silverado pickup truck. The court ordered a pre-sentence report. I've reviewed that. Have each of the attorneys had an opportunity to review the summary?
The state has, Your Honor.
We have, sir.
All right. Anything from the state?
Your Honor, I would ask that the court follow the joint recommendation in this case. The forfeiture of the property that is outlined in count 4 of the bill of information would be to the Highland County Sheriff's Office. I would ask that the clerk be ordered to issue a title for the vehicle to the county commissioners. And the total restitution in this case is $1,725.28 to the county commissioners. Thank you.
Mr. Wagner?
Your Honor, we had asked the court to follow the recommendation of the parties. That being said, much as this is an agreed upon representation, even for my court, I know the court's packed today. I will try to be brief. Just a little to the court is aware of who Wade is, and I guess more again for my satisfaction. Your Honor, Wade's 51 years old. He's married. He has a son that's been in my office. He has a wife that's been in my office multiple times. We talk on a weekly basis. You can see his family sitting here where I got 6 people here. They've come to my office in groups. They come to court in groups. I guess what I'm getting at, Your Honor, is this is, I've been doing this 22 years now. This is by far the #1 on my list of a quality guy who just made a stupid mistake, Your Honor, the night in question. He was driving down this country road where he resides. Someone blasted out his side window with a shotgun with no provocation. And that's where Wade went off on the beaten path. As opposed to going home, calling sheriff deputies, he retaliated. So again, I'm not justifying his actions afterwards. This is just not something that he instigated on his own. From that point, again, he did go back to the scene. He got himself in trouble at that point. He should have stopped with the police deputies. But again, Judge, this is a guy that works, has a family, raises a family, has a wife. He did get into substance abuse treatment. This was alcohol-related, Judge. It's clearly what it was. It just, and again, I've said this in front of you several times that I, actually like my client, not what they did. But this is one, Your Honor, where I sincerely, Wade does tree services, that if I ever had a problem, this would be the guy I would call. That's not to make him feel good or his family, but this is a guy, Your Honor, that I just hated. I'll never forget this case. Just a quality, good guy that made a stupid mistake, Your Honor. That's it, sir.
Mr. Page, anything you'd like to say? Well, other than this, you've had some alcohol problems in the past, tried to deal with them, didn't work. You're still using alcohol. It's a perfect example of the fact that alcohol and guns aren't a good combination, just like vehicles and guns aren't, or vehicles and alcohol aren't a good combination. And unfortunately, in this case, you were doing both. And then also you got angry at people that you apparently didn't like, and I can understand that. We all have people that we know we don't like. You've got neighbors, you don't have to like them, you just have to, get along, or at least, not engage with each other. And, it's, in this case, you got a case of road rage, and just went off. And, regardless of what the excuse was, or what you feel that they did that caused you to do this, it was wrong. And it's unfortunately you're under the influence of alcohol, not using very good judgment, although your statement said that you were raised that if somebody did wrong to you, you do the same back to them, but that's wrong in today's world. That's been wrong in the world for thousands of years. We have laws. We don't get to extract an ear for an eye for an eye, an ear for ear, like in the Bible. That's metaphorical, but that's not the real rule. It's never been the law in this country since we were founded, or going back further, unless it was meted out by justice, by courts. And that's what, something like that is wrong, that's what you should have done, like your attorney said. And unfortunately, what you've done is gotten yourself in a situation where, jail time is mandatory and has to be served. So, it's unfortunate that, at this point in your life, you've done this. That being said, the one thing about it is that, you still have can have a real long, healthy life once you get out of prison, if you, get off of the booze and stay off the booze, and get some counseling for anger management and try to deal with things in a better manner. And so, it doesn't make anybody happy in this case, the sheriff's department, prosecutor, myself, to sentence a man who's led a decent life. But when you do bad things, you have to be accountable. We can take that into consideration in the sentence, and prosecutors take it into consideration in their offer. And so the court is going to follow the plea agreement at this point, and it's the order of the court that you be sentenced on count 1 to a term of 11 months to Correctional Reception Center, to a term of 2 years on count 2, and 24 months on count 3. Now, the sentence in count 2 is 2 years as a minimum, because under the law, the Department of Corrections could, at the conclusion of that term, decide to extend it by up to 1 year. They can extend it up by 1/2 if they choose to do so. That's up to them. The court has no involvement with that. So count 2, the sentence is 2 years up to a total of 3. All of those sentences are to be served consecutively. First of all, that's the agreement of the parties. Secondly, the court finds that these offenses were committed as a continuing course of conduct, but it was different violations, and one single sentence would not adequately reflect the seriousness of the offense. and the sentences that are being imposed are not disproportionate to the harm caused. They're being on the lower of the maximum sentence could have been 8 years, 9 months to 16 and a half years, so we're significantly below that. But those will all be ordered to be served consecutively. It's also ordered that the property in count 4 be forfeited to the Highland County Commissioners, the vehicle specifically, be ordered to be tried title to the Highland County Commissioners by the clerk, and the weapon forfeited to the Sheriff's Department. Now, it's also ordered that you make restitution in the amount of $1,725.28, and that's payable through the Highland County Victim Witness Restitution Escrow Account. You'll pay any service fees that are connected with that, for that service. Now, upon completion of your prison term, if you should have to serve the entire term and not be given judicial release, then it is mandatory that you be put under post-release control supervision as to count 2 for a period of at least 18 months up to a maximum of 3 years. The other counts, it would be optional up to 2 years, but it is mandatory on count 2. So if that'll be at least 18 months up to 3 years. If that happens, if you do serve the entire term and do PRC time, then you'll be supervised by a parole officer in the terms they set. And if during that period of time they determine that you have failed to comply, they can return you to prison to make you serve an additional period of up to 9 months for a single violation, up to half of your prison term for all violations. But if you commit a new felony, in addition, whatever sentence a judge in the new felony case can impose upon you, that judge could also sentence you for committing that offense while under post-release control, in this case, to an additional period of a year, whatever time is left on that period of post-release control, whichever is greater. And if that occurs, that has to be served consecutively to the sentence in a new case. You're also ordered to pay the court cost for which judgment is granted and execution is ordered. If you do not do that or make payment arrangements for that, then the clerk can collect that through various means, including levying on bank accounts, wages, earnings, or other assets that you may have. If that doesn't collect it, then upon completion of your prison term, not while you're in prison, you can be permitted to do community service, and the court will give you credit for each hour you work, and an hourly rate set by the court. Each hour you work will reduce your judgment by that amount until paid full. I don't have jail time credit on you.
They were maxed up.
Okay. Trying to look here. How many days were you in jail before you made bond, Mr. Page?
He thinks 3, Your Honor. I don't want to
Okay.
100% tell you that.
Okay, here's the bond. It was posted on November 31st of October, filed on November the 1st. And so the arrest date was October 28th, so that'd be 4 days. 4 days jail time credit. All right. Anything further from counsel?
Just the mandatory driver's license suspension.
Oh, thank you. Yeah, in regard to suspend your license on the fleeing and eluding. And so the court will suspend that for 3 years, beginning today. So most of that will be done if you get your judicial release. But if it's not, then upon proof of insurance and that you have no other suspensions and your driving privileges would be intact otherwise, the court would grant you limited driving privileges for the remainder of that suspension. All right. Anything further?
No, Your Honor.
All right, that'd be count 3. All right, you're remanded in custody. let them know I'm reopening it. All right, but I gotta wait for Miss Barger to get on for that then. So go ahead, take us off that one. So that's Bobby Foster, is that one. Okay, Darcy Vinegar. All right, this is, oh wait, I can't get to it. Yeah, I thought so too, but I open it up here and it's not there. It's got pre-trials there and, yeah, no, for some reason.
Recording stopped.
All right. Wait a minute, Ben. Oh, never mind, I've got it. All right, case number 22 CR 251, State of Ohio versus Marty Martin. Present for the state is Assistant Prosecutor King. Present on behalf of the defendant is Attorney Catherine Hapner. You're Marty Martin?
Yes, Your Honor.
All right. Mr. Martin has entered a plea of guilty to receiving stolen property, a fourth-degree felony. The court referred the matter for a pre-sentence report. I have received that and reviewed that. Have each of the attorneys had an opportunity to review a summary?
State has, Your Honor.
I have, Your Honor.
All right. Anything from the state?
Only was contained in the plea agreement, Your Honor, and there is no restitution in this case. Thank you.
All right. Now, I had a victim witness impact state that said they wish to address the court as a victim here.
No.
There you are.
Okay. All right, Ms. Hapner?
Thank you, Your Honor. We would ask that you follow the recommendation for community control. My client has no prior felonies. He did go to FRS and began a substance use disorder program, and he just completed that this week. I have his certificate of completion dated March the 6th, so that was just on Monday. So he is compliant. I don't believe there's been any issues with his pretrial supervision, and I believe that he is a good candidate for community control.
All right, Mr. Martin, anything you'd like to say?
No, Your Honor.
All right. Well, Mr. Martin, I'm looking at your pre-sentence report here, and as noted, you don't have any previous felony convictions, and so that's obviously not an issue. And I understand that you returned all the stuff that you had bought from the person that sold it. But there's a problem I'm having here, and that is your attitude. In your interview, well, you made this comment to the probation department. It said, I didn't do anything wrong. I bought some antiques off of Chris Hutchinson, and they were stolen, which I did know they were stolen until 2 days later when I came home from work. Cops at the house, people where they came from, and I told the cops where I got them, and I told the people to take what was theirs. I was sitting right in the front yard, the antiques I bought off of him. I'm on house arrest, and he's out running around. Fuck, I'm done buying any shit from anybody. Like I say, I gave people their stuff and told them, I'm sorry, I didn't do a damn thing wrong. I bought some stuff that was stolen. If I would have known that, I wouldn't have bought the shit. I pled guilty to something I didn't ever do, and that's bullshit. And he made that statement. But that's not true, because you told the officer when they came to your house that you purchased the items from Chris Hutchinson. The officer said all those items were stolen, and you said most of the stuff Chris sells is probably stolen. Now the law says that you can't buy something or receive something that you know or have reasonable cause to believe has been obtained through the commission of a theft offense. So by your own admission, you admitted to the deputy that you had reasonable cause to believe it was stolen because you said half of the stuff he sells is probably stolen. But yet you get on this attitude with the probation department. So that doesn't bode well for your future compliance if that's the kind of attitude that you have. But nonetheless, you are still going to get community control because the law says that since you haven't been previously convicted of a felony, that you must get receiving stolen property. And even if not for that, despite your attitude, which I am going to address in the order, I would give you community control. So it's the order of the court that you be put on community control for a period of 3 years under these conditions. You'll be required to obey all laws of all jurisdictions, conduct yourself in a law-abiding manner at all times. You report to the probation department when and as directed. You're to be honest in all the responses that you give to them regarding your supervision. You are required to keep them informed of your residence and place of employment at all times. You may not change either without prior permission. You may not leave the state of Ohio at any time without prior written permission. You may not enter upon the grounds of any correctional facility, nor may you communicate with or attempt to communicate with anyone who's an inmate in any of those facilities without prior written permission. You're prohibited while you're under community control from possessing, owning, purchasing, using, or having under control any firearms, ammunition, dangerous ordnance, or weapons of any other type. You are not permitted to purchase, possess, use, or have under your control any controlled substance, drug of abuse, CBD oil, kratom, or any variant or analog of a controlled substance that has effects similar to those or drugs of abuse, nor any other instrument that may be used to administer them or prepare their administration, unless you have a valid prescription. You must provide a copy of that to the probation department prior, within 24 hours, I should say, of receipt. You're not to purchase, possess, use, or have under your control any alcoholic beverages, nor may you be present in places where they're sold or being consumed, even if that's otherwise lawful. You're not to associate with anyone who has a criminal record, a member of a gang, or any co-defendant in this case, or any other person who has in the past or could in the future influence you to commit a criminal offense or violate these conditions. And applies to any family members that fall within that definition, unless you've been living with them immediately before you committed this crime. After the date of this order, you may not marry or establish cohabitation in a common law marriage type relationship with another without prior permission. You must report any contact with law enforcement or any arrest, citation, conviction, or other charge violating the law not later than the next business day after that occurs. You'll provide financial information and records so your ability to pay restitution, well, that's paid, or if there is none, fees or costs can be reviewed. If you are referred for an evaluation or assessment for any further treatment, therapy, counseling, training, or programming by probation departments, you'll submit to that. And if they recommend any programming, you'll enroll in and successfully complete that. You'll pay a monthly supervision fee of $50 per month, beginning May 1, to the clerk of courts to be credited to the county supervision fund. You'll pay the court costs of this action, make payment arrangements to do that. Now, by being placed on community control, you're deemed to have consented to a search without a warrant of your person, residence, vehicles owned by you, used by you, or any other property place that's under your control, or where you're found at any time by any officer of the probation department. There won't be any fine imposed. Now, if you fail to pay the court costs, then the clerk can collect that through various means, including levying on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then upon completion if that doesn't do it, then the court could order you to do community service and give you credit in each hour you work, and in another rate set by the court, each hour you work will reduce your judgment by that amount until paid in full. Now, in the event that the probation department feels that you have failed to comply with this condition, any of these conditions, they'll file a written notice of that with the court. A hearing will be held. You'll be entitled to have an attorney. If the outcome of that hearing is that you have failed to comply, then the court can revoke your community control and sentence you to prison for between 6 and 18 months and fine you $5,000. If that occurs, once you complete that sentence, the law provides that the adult parole authority, as part of the sentence, may put you under post-release control supervision for a period of up to 2 years, and if during that period of time you fail to comply, then they could return you to prison to make you serve an additional period of up to half of your prison term for one or more violations. However, if your violation is a new felony, then in addition to whatever sentence the judge in the new case can impose upon you, that judge could also sentence you for committing that offense while under post-release control in this case to a period of 1 year or whatever time is left on that period of post-release control, whichever is greater. And if that occurs, that has to be served consecutively to the sentence in the new case. Now, as a final condition, just to let you know that your attitude appears to be a major problem. And just to give you a little time to think about that, it's ordered that you serve a period of 10 days in a county jail beginning now. And then upon release, you report to the probation department. Anything further, counsel?
No, Your Honor.
All right, you're remanded to custody. All right, this is case number 22 CR 133, Kelly M. Humphrey. This is a Zoom hearing. It was scheduled for an intervention in lieu plea. Appearing on behalf of the states, the prosecutor Collins, appearing on behalf of the defendant Sarah Barger. Ms. Humphrey is not present, and the court will note that I have received notice from probation that the defendant has not had any contact since January the 18th. At which time, as I understand it, there was an incident. There's been another warrant issued for her out of that. Is that correct, Mr. Arzima?
That is correct.
All right. And so you've not heard anything from her since then?
No, not since.
Okay. Ms. Barger, you've heard nothing? All right. All right. Well, then the court will order that a warrant issue for her arrest and that case be put on inactive docket until she's brought before the court.
Judge,
Yeah.
I just want to make clear for the record, this is actually not a Zoom hearing.
Well, it is. We're on Zoom.
I know, but
This is a Zoom hearing.
Kelly was not.
I understand that, but she's not here in the courtroom either, for the record.
Okay, I just want to make that clear for the record.
Yeah, yeah, it wasn't noticed as such, but since she's not here, Ms. Barger was on Zoom, I wanted to do it that way.
Okay.
Yeah. All right, thank you. All right, now, Ms. Foster. Case number 22 CR 171, State of Ohio versus State of Ohio versus Bobby Renee Foster. This is a hearing set by Zoom for intervention. You, Bobby Foster, appearing on the phone there with the name Bobby Foster.
Sir.
All right, try to hold that still if you can. It's a little, okay. Ms. Foster's attorney is Sarah Barger, appearing from her office. Appearing from the prosecutor's office is Annika Collins, the prosecuting attorney. The defendant is charged with aggravated possession of methamphetamine and aggravated possession of drugs. And there was a motion filed for intervention in lieu of conviction. People, be quiet. Don't talk in the courtroom, and you're disturbing the proceedings. And the court referred the matter for a report, which I have received, and indicated that she is in a treatment program at Family Recovery, starting February the 6th. Now, I have received the paperwork. However, I also received a fax from Mr. Arjima, who's also on this hearing, indicating that Ms. Foster tested positive yesterday for kratom, methamphetamines, buprenorphine, and as of February 28, she had missed 6 group sessions at FRS, as being recommended for intensive outpatient. There were no other updates. So at this time, I'm not going to accept a TIL plea. What I am going to do, Mr. Arjima, is ask for, and I'm going to order Ms. Foster to report to Ms. Sturgill to be evaluated for residential treatment, because I think that that's going to be necessary. Ms. Barger?
She does have a bed date for tomorrow at Lake Golf.
Oh, okay. All right. Well, I don't have that information, or didn't. Okay.
It was before the hearing.
Gotcha.
And we
All
were
right.
able to work it out.
Now, your client's aware of that, Ms. Barger, I assume?
Yes, I did let her know before the hearing started.
Okay. Well, I'll tell you what I want to do in this case. I'm still going to defer this for a couple weeks, and I want to see her go in there on a voluntary basis and see how she's doing. And if you go in there, Miss Foster, and you stay, then we'll be all right. But if I go ahead and do this, send you out there, and you walk out the back door tomorrow after you go in the front door, and that happens all the time, then you know, you're going to be in here in a violation in a minute. And so I want to see if you're serious about this before we go any further. So I'm going to continue this to March, let's see here. I've been pushing so much. Huh. Well, I must have sent my, oh no, here it is. Continue this to April the 5th at 9 a.m. We'll do it by Zoom. That'll give you about 3 weeks to show that you're serious. And then if you don't stay in there, then TIL is probably not in your future. You understand? All right, so, and if you don't report there tomorrow, then upon notice from the probation department, we'll set a hearing sooner in order you appear in person before the court at another hearing. Anything further from council? 9 o'clock. All right, so April the 5th at 9 a.m. We can do that by Zoom if you're down at Lynn Golf. Then you won't have to come over. All right? All right, thank you. All right, now, Jeremiah Jackson. (22 CR 201). State of Ohio versus Darcy Vinegar. Appearing on behalf of the state is Assistant Prosecuting Attorney King. Here on behalf of the defendant is Attorney William Armentrout, and you are Darcy Vinegar.
Yes, Your Honor, I am.
All right. The defendant has entered a plea of guilty to counts 1, 3, 5, and 9 of the indictment, all aggravated trafficking methamphetamine, 2 fourth-degree felonies, 2 third-degree felonies. The matter was set for sentencing today. Anything from the state?
Only was contained in the plea agreement, Your Honor, and the restitution figures to the task force are also outlined in the plea agreement. Thank you.
Mr. Armentrout?
Stand up, Darcy. I would ask the court to follow the agreement. It is a recommended sentence with an actual imposition of sentence and a recommendation down the road for possible early release, so that will come up at a later time. All I can say about Darcy, she never missed an appointment in my office, always took my calls, I think was compliant through a pretrial. So we'd ask the court to impose the recommended sentence in this matter. We'll file other motions at the appropriate time.
All right, Ms. Vinegar, is there anything you'd like to say?
No, sir.
Well, I know you back in 2017 you had trafficking in heroin. You did community control and were successfully completed it, but apparently that didn't teach you anything because you're back here now on much more serious charges. And the thing that is disturbing is that, you know, it looks like you're one of those people that's in it for the money. And, you know, that's not a good thing. But you have taken responsibility and have cooperated with your attorney, and everything has been a positive since you've been charged. That's what we expect. But you know, you have done that. Not everybody does. So based on that, I am going to follow the recommendation, and it's the order of the court that you be and are hereby sentenced to a term to the Ohio State Reformatory for Women as follows. On count 1, 12 months. On count 3, 18 months. On count 5, 18 months. And on count 9, 11 months. Those sentences are ordered to be served consecutively to one another for a total of 4 years and 11 months. The court finds that consecutive sentences are necessary appropriate. First, the sentences that agreed upon one by the parties. Secondly, the offense was committed. The offense was committed as a series of misconduct, and that one single prison term will not adequately reflect the seriousness of the offense, and the sentences that are being imposed are not disproportionate to the harm caused. Also, your history of criminal conduct, being a repeat offender in trafficking, demonstrate that it's necessary to protect the public. You'll receive credit, according to this, you were in jail 7 days, 12/8 to 12/15. Is that correct?
Yes.
So you get 7 days of jail time credit. Now, upon completion of this prison term, it is possible the Adult Parole Authority will put you under post-release control for a period of up to 2 years. They don't have to, but they can. If they do, you'll be supervised by the terms the APA sets, and if during that period of time you fail to comply, they can return you to prison and make you serve an additional period of up to 9 months for any single violation, up to a maximum of half of your prison term for all violations. But if you commit a new felony, then in addition to whatever sentence a judge in the new case can impose upon you, that judge could also sentence you for committing that offense while under post-release control in this case to an additional period of a year, or whatever time is left on that period of post-release control, whichever is greater. If that occurs, that must be served consecutively, sentenced in a new case. You're also ordered to pay court costs, and if you fail to pay those or make payment arrangements, the clerk can collect that through various means, including levying on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then once you are out of prison, you'll be permitted to do community service in this county and be given credit for each hour you work in an hourly rate set by the court. Each hour you work will reduce your judgment by that amount until paid in full. Now, you're ordered to pay restitution to the Highland County Task Force, a loan $500, $20 joint and several with Harley J. Mustetter, and $120 jointly and severally with Jordy Scott Van Gundy. Those will be payable through the Highland County Victim Witness Restitution Escrow Account. You'll pay any service fees charged with that. That restitution is a substantive order that does not go away until it's paid or you die, whichever occurs first. Can't be discharged in bankruptcy. You can't work it off. You can't serve it out in jail. All right, is there anything further, counsel?
No, sir.
Just a mandatory fine, Your Honor.
Has there been any change in your financial circumstances since I appointed Mr. Wagner, or Mr. Arbitrage Representation?
No.
All right, then the court will waive the mandatory fine. All right, you're remanded to custody.
Good luck, Darcy.
All right, this is case number 23, CR 24, State of Ohio versus Aaron Hunt. You're Aaron Hunt?
Yes, sir.
Speak up.
Yes, sir. Yes,
okay. Mr. Hunt, you were indicted by the grand jury on February the 7th for failure to comply with order signal of a police officer and aggravated possession of methamphetamine. And you can tell the officers we're done with them now. We're done with them, so they can go. Count one alleges that on or about January 15th of this year in this county, you operated a motor vehicle so as to willfully elude or flee a police officer, and the operation of that vehicle caused a substantial risk of serious physical harm to persons and property. And then count two alleges on or about the same date, same in this county, you knowingly obtained, possessed, or used methamphetamine. Count one is a third-degree felony which carries a possible prison term between 9 and 36 months in increments provided by law. There's a fine of up to $10,000, mandatory license suspension of 3 years to life. Count two is a fifth-degree felony, carries a possible prison term between 6 and 12 months, fine of $2,500. Now, you are entitled to have an attorney to represent you, and if you cannot afford to hire one, the court will appoint one for you. And I see that you filled out no, you have not filled out a form yet. We don't have a form on you. Did you bring one in?
Well, I thought I filled one out when I went in and did my fingerprints.
Let me look. Oh, yes, you did.
Okay.
Here it is, February 21st. Okay, thank you. Is everything on this form still correct?
It should be, sir.
And it says you're self-employed. What are you doing?
I work for Purdon's Auto Parts Sales.
I'm sorry?
I work for Purdon's Auto Sales or Auto Parts Sales.
Okay. You're only making $800 a month?
Yes, sir. I'm looking for other employment.
I'll say I would think so. Yeah.
Yeah.
Okay. All right. Well, the court will find that you are entitled to appointed counsel. And I see you were bound over from grand jury. All right. We'll appoint Attorney Jacob Wagner to represent you, and in the absence of counsel, I'll enter a not guilty plea on your behalf. We'll set your first pretrial for March the 22nd at 2:30. You have a laptop or a smartphone, you can do video?
Yes, sir.
All right, so provide that information to the bailiff, and we'll do that by Zoom, so you don't have to come in.
Okay.
Your next pretrial will be April the 5th at same time, 2:30, and that'll also be by Zoom. And your trial date will be April 24th at 8 a.m. That will be in person. You'll be released on your own recognizance. You'll have to sign, oh, wait a minute, did you post a bond over in Greenfield? Is that an OR bond?
I did post.
$7,500?
Yes.
Who was that through?
Raging Cajun Bell.
Raging Cajun, okay. Oh, there it is, all right. So $7,500 plus your OR is continued, prior bonds approved, prior bond continued. And the OR is your promise to appear, and if you fail to appear, then you could be prosecuted for an additional felony, and if convicted, sentenced on that no matter what happens in this case. You'll be required to pay a deposit of $171 within 30 days of the clerk to cover certain statutory required fees. You'll be under pretrial supervision of the probation department. Are you already doing that?
Okay. No.
I should report to probation department, 117 East Main Street.
Okay.
You know where that is? Across from Flagway.
Okay.
It's right down there.
Yeah.
Report to them once a week for 4 weeks, and after that, as they determine, undergo random drug testing they may order. Provide phone numbers for home sound employer. If recommended by probation, be evaluated for substance abuse or mental health issues. If any treatments indicated, you'll enroll in and follow that during the pendency of this action. You'll also be under house arrest at your residence, meaning you have to be there at all times unless you're working, going to and from work, or looking for other work.
Yeah.
Medical appointments, court proceedings in this or any other case, appointments with an attorney or probation officer in this or any other case. You may also attend church services and any type of schooling, educational programming, job training, things of that sort. I see you do have minor children in the home.
Yes, sir.
So I'll allow you to take care of their, go to any activities of your sons and any appointments, etc. You can go to those.
Thank you.
And so you can also do your business affairs, like going to the grocery, the bank, pay your bills of that nature.
Okay.
But you'll have to notify the probation department about that whenever you're doing that. They'll go over that with you when you report down there today to explain to you how you make that happen.
Okay.
All right. You have any questions?
No, sir.
All right, then you're going to step over here, get an assignment notice, go down to the clerk, sign your bond, and make arrangements to pay your deposit, and then to the probation department.
Okay. Thank you.
Thank you. All right, are you Alicia Looney?
Yes.
Okay, this is case number 23 CR 31, State of Ohio versus Alicia Looney. So Looney, you were indicted by the grand jury of this county on the 7th of February for theft, a 5th degree felony. Alleges an on or about period between September 1 and November 1 of the past year, 2022. And in Highland County, Ohio, that you and Brandon Cannon did with purpose to deprive AVI Food Systems, the owner of property, knowingly obtain or exert control over that property, $4,214 in cash without their consent or person authorized to give consent. And that is because the amount is a 5th degree felony, carries a possible prison term between 6 and 12 months, and a fine of $2,500. Now, you are entitled to appointed counsel, and I see you have filled out a form, and everything on this is correct?
Yes.
All right, you're working at the Greenfield Skilled Nursing,
Yes.
and $1,400 per month?
Yeah.
That's your gross?
Yes. I mean, sometimes it's more, sometimes it's a little less.
Sure, but that's your basic?
Yeah.
Okay. Is this the first time you've been to court in this case?
Yes.
All All right, the court will find that you're entitled to appointed counsel. Appoint Attorney Dennis Kirk to represent you. His office is just down the street near the corner here. And I'll enter a not guilty plea on your behalf. Your first pretrial will be set for April the 5th at 2:30, and if you have a computer or smartphone, you can do it by video.
Okay.
So you give that information to the bailiff so we can have that to send you the invitation.
Okay.
It'll be a day or two before by email.
Okay.
And if your email changes, make sure you let us know.
Okay.
Your final pretrial will be May 3rd, 2:30 p.m. We'll do that by Zoom as well. And your trial will be May 8th. Oh, no, I'm sorry, not May 8th. June 12th at 8 a.m. That is in person.
Okay.
Your bond is your OR only, and that's your own recognizance. Your promise to appear. If you fail to appear, you could be prosecuted for an additional felony, and if convicted, sentenced on that, no matter what happens in this case. You're required to pay a deposit of $171 for certain statutorily required fees within 30 days. You make arrangements with the clerk when you go downstairs to sign your bond. You'll be under pretrial supervision of the probation department at 117 East Main Street. It's just down the street here across from the Flagway Station on the opposite side of the street from the courthouse. You'll report to there immediately after court. You must report to them once a week for 4 weeks, and after that, as they determine, undergo random drug testing they may order. Provide phone numbers for home, cell, and employer. Have no contact with the alleged victim. If recommended by probation, be evaluated for substance abuse or mental health issues. If any treatments indicated, you're to enroll in and follow that during the pendency of this action. And you'll also be under house arrest at your residence, which is 5754 State Route 138.
Yes.
That means you have to be there at all times, unless you're working, going to and from work, medical appointments, court proceedings, in this or any other case, appointments with an attorney or probation officer, in this or any other case. You can attend any kind of job training, educational programming, classes, GED, college, etc., church activities. I see you have minor children?
Yeah.
All right. And you can do anything with your children's activities, appointments. And it looks like Mr. Cannon's our next case, so since you're both going to be in house arrest, I'll let you do your business affairs like going to the grocery, paying your bills, things of that nature, but you will have to report to the probation department in advance and let them know when you're going to do those activities directly and back. Did you get fingerprinted and photographed when you went to the sheriff's office?
Yes.
Okay. All right. Do you have any questions?
No.
Are you step around here, sign your appearance notice, or get down to the clerk's office to sign your bond and make payment arrangements, then to the probation department. All right, Brandon Cannon. He'll log him back in. Yeah, Jackson. They haven't logged back in. Got everybody else here. We've had them for several minutes. All right, you're Brandon Cannon?
Yes, sir.
All right, this is case number 23CR32, State of Ohio versus Brandon A. Cannon. And Mr. Cannon, I just arraigned Ms. Looney. You're facing the same charge as her. You heard me read that. You know the charge?
Yes, ma'am.
All right.
Yes, sir.
You are waiving reading the charge in? You'll waive. You don't want me to read it again?
No,
all right.
I need you to read it again, sir.
You understand? All right.
Yes, I understand.
Okay. Now, you are entitled to an attorney, and if you can't afford to hire one, the court will appoint one for you. And I have your financial disclosure form here, and everything on this is correct?
Yes.
You're not employed at the present time?
Not at the present time, thanks, sir.
All right. Court will find that you are entitled to appointed counsel. I'll appoint Attorney William Armentrout to represent you. And in the absence of, wait a minute here, yeah, okay. William Armentrout to represent you. And in the absence of counsel, I'll enter a not guilty plea on your behalf. And we'll do your hearing the same as Ms. Looney's, March the 22nd at 2:30 by Zoom. I'm sorry. I'm looking at the wrong file. Thank you. Oh, here it is. Okay, what was it again, 4-5?
4-5.
Okay.
5-3. 6-12.
It's 6/12, okay.
2:30
All right, so 2:30 on April 5 and May 3, and I assume you can use the same device she has to do this by Zoom, so you don't have to come here. Your trial will be 8 o'clock in the morning on the 12th in person. You're released on your own recognizance as well, which is your promise to appear. If you don't appear, you could be prosecuted for an additional felony, and if convicted, sentenced no matter what happens in this case. You'll also be under pretrial supervision of the probation department, 117 East Main Street. Report there immediately upon release after you get done downstairs. You'll report to them once a week for 4 weeks. After that, as they determine, undergo random drug testing, provide phone numbers for a home, cell, employer. Have no contact with the victim. Recommended by probation, be evaluated for substance abuse or mental health issues. If any treatment's indicated, enroll in and follow that during the period of this action. You'll also be under house arrest, meaning you have to be there at all times unless you're working, going to and from work, looking for work, medical appointments, court proceedings, appointments with an attorney, a probation officer, in this or any other case, any school, educational, job training, anything of that nature, or any church services. Other than that, and also allow you to do your, are the children, those your children as well?
Yes, sir.
All right. I put sons on hers. I didn't realize there's a daughter there. I just saw, I think, Kia Herrera, I assume that's a daughter?
Yeah, Kia.
Oh, yeah, there it is. Okay.
Yeah, on par.
Actually, there's two of them. Okay. So, children's activities, appointments, and business affairs. Other than that, you have to be there at all times, and you'll make, probation will explain to you how that works.
Okay.
All right. You stop downstairs, and you did get fingerprinted and photographed?
Yes, yes,
Okay.
sir.
After you get your assignment notice, go downstairs, sign your bond, make payment arrangements, then go to the probation. Also, they'll give you, and Ms. Looney, numbers for your attorneys, and you should contact them and give them your contact information so they can be in touch with you as well.
Okay.
You have any questions?
No, sir.
All right, thank you. All right, what's going on with the sheriff? He's on. Yeah, he's back in the jury room. All right, case number 22 CR 251, Jeremiah Lynn Jackson. You're Jeremiah Lynn Jackson appearing there on the screen from the Sheriff's Department?
Yes, Your Honor.
All right. Your attorney is Jacob Wagner. He is appearing by video on his phone, and appearing on behalf of the prosecutor's office is prosecuting attorney Collins. The defendant has entered a plea of guilty to count 1, attempted grand theft of a firearm, 4th-degree felony, and count 2, breaking and entering, a 5th-degree felony. Court ordered a pre-sentence report. I have reviewed that. Have each of the attorneys had opportunity to review a summary?
State has, Your Honor.
All right.
We have, Your Honor.
Okay. Anything from the state regarding sentencing?
Yes, Your Honor, the state would ask the court to follow the joint recommendation in this case. Would note that Mr. Jackson has no prior felony history, and House Bill 86 would be in play here. Would note that the victim of the attempted theft of the firearm was notified and approved the agreement and understood it. The owner of the property for the B&E was notified, does not believe House Bill 86 actually exists, and would not have been happy with the death penalty in this case. So, but he has been notified.
All right. Anything from the defense?
Your Honor, we just asked the court to follow the recommendation. I know there were some Pike County matters that were hanging out there. It's my understanding those have been resolved. So I know there's a bed available. I thought it was tomorrow, but I think it might be either Friday or Monday. But there is a bed available, Your Honor.
Mr. Arjima, do we have confirmation of the date on the?
Let me check with Mr.
What bed? What facility is that? Do you know, Mr. Wagner?
I don't. Tanya's actually, she was right outside. Before I walked in, she told me that the bed had got bumped from Thursday to Monday.
Okay. All right, if you can find that out, Mr. Arjima, while we're working on this. Mr. Jackson, you have anything you'd like to say?
No, Your Honor. Just appreciate the opportunity. Treatment.
Well, Mr. Jackson, you've had some chances in the past. It's been a while ago, but I see you've been to STAR back in 2011, and then I believe I saw you'd also completed another program, I believe I saw.
Recovery Council.
Yeah. So, you know, I know you said you appreciate the chance. You've had some chances, but, you know, it's time for you to get serious about it and not just look at it as a way of staying out of jail and coming back, because at some point, some judge, like me, is going to lose patience and just going to say, you know what, it's not going to work. Let's just do your time and get it over with. But I'm going to go ahead and follow the recommendation, put you on community control for a period of 3 years under these conditions. You're to obey all laws of all jurisdictions, conduct yourself in law-abiding manner at all times. You're to report when and as directed, to be truthful in all answers you give to questions about your community control. You must keep them informed of your residence, place, and employment at all times. May not change either without prior permission. You may not leave the state of Ohio at any time without prior written permission. You may not enter upon the grounds of any correctional facility, nor may you communicate with or attempt to communicate with anyone who's an inmate in any of those facilities without prior written permission. You may not purchase, possess, own, use, or have under your control any kind of a firearm, ammunition, dangerous weapon, or any other weapon of any type. You are not permitted to purchase, possess, use, or have under your control any controlled substance, drug of abuse, kratom, CBD oil, any variant or analog of a drug, controlled substance, or drug of abuse that would have effects that are similar to those. May not have any items or equipment that can be used to administer or prepare drugs for administration unless you have a lawful prescription for those as well as the drug, in which case you must provide a copy of that within 24 hours of receipt. You're to submit to drug testing when and as directed. You may not purchase, possess, use, or have under your control any alcoholic beverage, nor may you be present in places where they're sold or being consumed, even if it's otherwise lawful. You're not to associate with anyone who might have been a co-defendant in this case, or any other person who has a criminal record, a member of a gang or any other criminal group, or any person who has in the past or could in the future influence you to commit a criminal offense or violate these conditions. That applies to any family members that may fall within that definition, unless you were residing with them immediately before the offenses were committed. You may not, after the date of this order, marry or establish cohabitation in a common law marriage type relationship without another without written permission. There's report anytime you come into contact with law enforcement or you're charged, convicted of any type of offense. You must inform the probation department of that within 24 hours of its occurrence. You must provide them with financial information so your ability to pay any fees or costs can be reviewed. You'll be required to pay court costs and make payment arrangements to do this. You'll be required to do 400 hours of community service rated 20 hours per week for 20 consecutive weeks. Once you complete treatment, unless you're employed at least 20 hours a week, a full-time student, or you have documentation by a physician or prior disability finding that you're physically unable to do that. Here to be, there's no restitution, Ms. Collins? Okay.
No, Your Honor, the gun was not even taken.
Okay. You'll be required to successfully complete substance use disorder, SUD, residential treatment and aftercare as arranged by the probation department. Do you have information on that?
It's the recovery council, Your Honor.
Okay. And what is the bed date?
Monday.
March 10. No.
13.
13. All right. And then you'll remain in jail until conveyed to the recovery council. Now, you're also, by being placed in community control rather than being sentenced to prison, deemed to have consented to a search without a warrant of your person, your residence, vehicles owned by you or used by you, any other property place that's under your control, or where you're found at any time by any officer of the probation department. Now, in the event that it's alleged, and you're also ordered to pay the court costs as a substantive order, and if you don't make payment arrangements to do that, then the clerk can collect that through various means, including levying on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then could be ordered to do community service. Beyond that, ordered by the court already, and be given credit for each hour you work, and an hourly rate set by the court each hour you work will reduce your judgment by that amount until paid in full. Now, upon completion of your prison term, should you be required to serve the term, the law provides that, if you are, first of all, if you fail to comply, probation department will notify you of that in writing, and then the court will have a hearing. You'll be entitled to have an attorney. If the outcome of that hearing is that you fail to comply, then you can be sentenced to a period of between 6 and 30 months and fined $7,500. If that occurs, once you complete that prison term, the adult parole authority may put you under post-release control for a period of up to 2 years under terms they set, and if they determine that you fail to comply, they could return you to prison to make you serve an additional period of up to 9 months for a single violation, but there is a cap or limit of half of the prison term for one or more violations. But if you commit a new felony, then an additional whatever sentence a judge, a new case can impose upon you, that judge could also sentence you to an additional period of 1 year, whatever time is left on that period of post-release control, whichever is greater. If that occurs, that must be served consecutively to the sentence of the new case. All right, is there anything further in counsel?
Yes, sir.
All right, Mr. Wagner, Ms. Collins, just for this afternoon, we have, I think, 20 cases. So I want us to try to start in a few minutes before 1 if we can. So.
I don't have any, but yes.
Okay. Oh, you don't have any? Okay.
I'm moving on, Martin, Judge.
Oh, okay. Good for you. All right. Thank you.
Thank you.
Recording in progress.
Let's see. How far down is that supposed to be? All right, case number 23, CR 27, State of Ohio versus Ronald W. Shepard. Present for the state is Assistant Prosecuting Attorney King. Present for the defendant is Chelsea Panzica.
Yes,
and
Judge.
Anna Blau.
Yes, Your Honor.
And you are Ronald Shepard.
Yes.
All right, Mr. Shepard is charged with gross sexual imposition, third-degree felony. This matter is set for a final pretrial on April 5th and a trial on April 27th. I see the state has provided a bill of particulars and discovery on the 15th of February. And I don't see discovery from the defense yet. Have you provided that yet?
Judge, so we actually just signed on to the case, did a notice of substitution. I did pick up what appears to be paper discovery from Mr. Armentrout's office just before court, and I did just drop off a flash drive to Mr. King's office because I think there's quite a few videos and everything we need to get. So we
Okay.
haven't actually reviewed discovery yet. Like I said, we just picked up the paper today.
Right.
So I'm hoping by next pretrial on the 5th, we'll have a better understanding of discovery being exchanged and if
Well,
there's
the
any-
rule is it will be done by the final pretrial. That is the rule.
We
And
can
then
do that.
also any pretrial motions will be due by that time as well. Was there a written plea offer included in the materials?
Yes, Your Honor.
You have that?
Yes, Judge.
All right. Is your client aware of it?
Not yet, Judge. We haven't discussed
Right.
it.
Do you anticipate any pretrial motions at this point?
I don't know yet until I review the discovery, Judge. I will
Okay.
review it as soon as I can.
All right.
And Your Honor, the only other conflict I talked to Mr. King about was the trial schedule. I know Mr. Bliley, co-counsel, is in trial that week, and I've got something on the 27th in Hamilton County as well. So I don't know if you want to address that now or at the final pretrial, or have me file a motion to continue.
Well, you know, I usually tell counsel that before we get in a case that you know you have a conflict on to check about that, to see about the continuance situation. Now, on this case, I don't think we have a speedy trial problem. He's been on bond, hasn't he?
Yes, Judge.
All right. So if you want to, what is the conflict? You both have pre-existing?
I have got a civil protection order in Hamilton County, Ohio on the 27th.
Can I turn on my phone, Your Honor? Ask permission.
Yeah, go ahead.
I think it's Daniel's. I don't know what county it is.
Sorry, sir, I'm trying to observe your rules. And
Yeah, that's fine.
Here.
Yeah, but
Do you know what county it's in?
I don't, but it's going,
Commonwealth of Kentucky.
yeah, it's Kentucky, but I don't remember what county it is. It's like Madison, I think.
Mr. Bliley, according to his calendar, starts a jury, he believes in Madison County,
It is.
Kentucky.
I'm almost positive it's Madison. I'm co-counsel on it, but I'm
All
trying
right.
to see.
What about May the 8th?
I think Your Honor, I don't hear very well. And
May 8th?
And I think you're asking that for a trial date?
Yes.
Judge, I'm technically on maternity leave, but assuming these babies don't come that week, then my whole calendar's blocked out for May for maternity leave, so.
For what? For what?
For maternity leave.
Okay. What's your expected date?
Expected date, I have childcare lined up August 15.
No, so what is your expected delivery date?
Oh, I'm sorry. It's May 25th, however, with twins, they're expecting the first week of May.
All right.
So my doctor just said block off the month.
Well, I'm not going to continue this for 12 weeks because of maternity leave for somebody who came into a case that already had a trial date. So,
Why don't we,
I'll go June the 12th is the latest I can go.
Can we go ahead and do the May 8th date? I think that'd be safer than
All right.
June.
May 8th? Okay. Then we'll go ahead and set it for May 8th at 8 a.m. I'll grant the motion to continue. The speedy trial time is told pursuant to 2945-72H.
Judge, did you say 8 a.m.?
8 a.m. And we'll go ahead and extend the, since we're postponing that, we can extend the final pretrial to April 19 if you're available. Or not. If not, we'll leave it on the 5th. But
April 19th would be perfect.
we can do that by Zoom.
Perfect.
So 2:30 available?
Yes.
All right, we'll do that by Zoom.
And that would then vacate the April 5th?
Vacate April 5th.
Okay.
Yeah. All right. Now, any other matters we need to discuss?
Nothing from the state.
No, Judge.
All right. Mr. Shepherd, I have one to discuss with you. You were released after arraignment on February the 10th. You were ordered to report to the probation department. You have not done so. So you are to go immediately from here down to the probation department. You're on pretrial supervision. You're supposed to report once a week for 4 weeks, and then after that as determined. And I also outlined the conditions. So you get down there right now. When you get down there, ask them to contact the court to confirm you're there. The pretrial supervision conditions are there for a reason. I expect them to be obeyed. That includes house arrest and all the other things that I put in there. And if I get another one of these messages that says you're non-compliant, probably going to have a warrant issued for you, and we're going to have a hearing on whether or not your bond needs to be modified in order to make sure that you comply with the rules of the court. So, do you have any questions about what that means? Because I thought it was very clear on our arraignment. I'm known for being pretty plain spoken, and I also, I think, asked if you had any questions. I know you had your attorney here, but I don't think there was any confusion on anybody's part. And you need to understand that when I tell you to do something, I expect you to do it. When I tell the attorneys to do something, I expect them to do it. So you need to understand that, I'm pretty direct, but when I say something, I mean it. I don't bluff. I don't bluff. So you need to understand that. So you're going to go right down to court here. It's about 300 yards or less, probably 200 yards. So you should be able to make it in 5 minutes easy.
we're going to make, Judge, I agree with you. I'm going to make sure this happens. Is that, so I make sure that he's compliant with it. Would that happen to be on an order, or I just want to make sure I'm fully informed.
Should it be a what?
Remember, I'm having a hard time hearing. I'm taking a guess, all his pretrial requirements are probably on some order somewhere.
Yeah, in the arraignment entry, should have got a copy of it.
I'm not doubting it, Judge.
And I told it to him when we arraigned him.
Not doubting you all, I just want to make sure that I make
Well,
sure.
I hope you're not, because it's pretty clear, so,
I'm with
I
you.
don't think what you did helped any. It just seems to seem, nobody here seems to be taking me seriously. Better. All right, you're done. Thank you.
Thank you, Judge.
sir.
You have to go to probation right after this.
Case number 22 CR 41, State of Ohio versus Jonathan M. Cumberland. You're Jonathan M. Cumberland appearing there from the jail?
Yes, sir.
All right, Mr. Cumberland's attorney is Dennis Kirk, appearing from his office, and appearing from the prosecutor's office is Prosecuting Attorney Collins. This is a Zoom pretrial. Mr. Cumberland's charged with 2 counts of, well, actually 1 count of aggravated trafficking, 1 count of aggravated possession of methamphetamine. First pretrial, or actually it's the final pretrial. Trial is set for March the 23rd. Now, I see that the state provided discovery. I don't see your discovery yet, Mr. Kirk. Did you get that done? You're muted.
Your Honor, we submitted a plea form, and the intention was to plead guilty today.
Oh, I'm sorry. Here it is. I thought that went with a different file. I didn't look at the name. Okay. All right. So, Mr. Cumberland, I've got this form here that says you're going to plead guilty to count 1. So I'm going to hold this up to the camera. It shows your name and case number and a plea of guilty form. You see that form there?
Yes, sir.
And you recognize it?
Yes, sir.
On page 3, there are signature lines. About halfway down that page, there's a sentence that reads, "I enter this plea voluntarily." Right below that, there's a line for signature defendant. I can read John. I assume that's Cumberland right behind it. I'll hold that up. And is that your signature?
Yes, sir.
When did you sign this document, Mr. Cumberland?
Yesterday, sir.
All right. Now, when you signed this document, did you understand that it was an agreement to plead guilty, which means there won't be a trial, and the next step in your case would be a sentencing?
Yes, sir.
And did your attorney go over this with you and explain everything to you before you signed it?
Yes, sir.
And did you have enough time to fully consider this matter before you signed this document?
I did, sir.
Do you still want to go forward with the agreement today?
Yes, sir.
And did you enter into the agreement to plead voluntarily, to plead guilty voluntarily?
Yes, sir.
Right now, the agreement says you're going to plead guilty to count 1, aggravated trafficking methamphetamine under 2925.03A1, a third-degree felony. It says you understand that that carries a possible penalty in prison of between 9 and 36 months. There's certain levels provided by law, goes from 9 to 12 to 18, and then every 6 months up to 36. There's a fine of up to $10,000. There's a mandatory fine of $5,000, and there's a possible license suspension of 6 months to 5 years. And prison term is presumed to be necessary by the law. It's not mandatory, but that's what the legislature says. In most cases, that sentence should be a prison term. Do you understand that?
Yes, sir.
Do you have any other felony charges pending against you in any jurisdiction?
No, sir.
Are you currently on probation, parole, community control, or post-release control for a felony from any jurisdiction?
No, sir.
Now, under the law, Mr. Cumberland, if you should be convicted of this offense, and if you should be sentenced to prison, then upon completion of that prison term, additional part of the sentence is that the adult parole authority, under the law, can decide to put you under post-release control supervision excuse me, for a period of up to 2 years, which means you'd be supervised by a parole officer in the terms that they set. If they do and you fail to comply with those conditions, they can return you to prison to make you serve an additional period of up to 9 months for a single violation or half of your prison term for all violations. However, if you commit a new felony while under post-release control, then in addition to whatever sentence could be imposed for the new felony conviction, the judge in that case could also sentence you to an additional term for committing that offense while in post-release control, in this case, of 1 year or whatever time is left on that period of post-release control, whichever is greater. And if that occurred, that would have to be served consecutively, the sentence in the new case. You understand that?
Yes, sir.
Now, as I said, it's not mandatory that I sentence you to prison, although it's presumed that it should be a prison term. So legally, it's possible to be put under community control or probation, meaning to be supervised for a period of up to 5 years by a probation officer under terms set by the court. If during that period of time, probation department felt that you were non-compliant, they would file a written notice of that with the court. There would be a hearing. If the outcome of that hearing was you failed to comply, then at that time, the court could revoke your community control and then sentence you to 36 months and fine you the $10,000. Do you understand? jail time credits? Yes. Okay. All right, now, the charge in this case reads that on or about April 26, 2021, Highland County, Ohio, you and Heather Trevette did knowingly sell or offer to sell methamphetamine, a Schedule II controlled substance, an amount equal to or exceeding bulk amount but less than 5 times bulk amount, in violation of Section 2925.0381 of the Higher Revised Code. So that's the aggravated trafficking in methamphetamine, third-degree felony with the penalties I've just described. Now, Mr. Cumberland, do you understand what you've been charged with, what the state said you did, when, where, and how they allege that you did it?
Yes, sir.
And have you discussed the nature of the charge, the evidence in the case, possible legal issues in the case, possible defenses you could try to raise at trial, and the possible outcomes of a trial with your attorney?
Yes, sir.
And are you satisfied with his advice and competence in this matter?
Yes, sir.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Has anyone threatened you to make you plead guilty?
No, sir.
All right, now on page 2, there are several lines that are printed in bold, ink, and underline, and those set forth the primary terms of the plea agreement, so I will read those as follows. Defendant shall enter a plea of guilty to count 1. State will dismiss count 2. State and defense jointly recommend 12 months incarceration. Defendant agrees to pay back buy money to the Highland County Task Force in the amount of $220, joint and severally with Heather Trevette, and defendant agrees to cooperate fully with the task force. Is that your understanding of the agreement?
Yes, sir.
Has anyone promised you anything other than that to get you to plead guilty here today?
No, sir.
All right, now, under the law, Mr. Cumberland, the matter of sentence is up to the judge, not the parties. And so even though there's a stipulation as to what the sentence should be, once I've heard all the information, if I decide that's not the correct sentence, I could choose to sentence you to a sentence of as much as 36 months or as little as 9 months. I could fine you $10,000. I could also suspend your license for 6 months to 5 years. Do you understand that?
Yes, sir.
Now, do you hold any license or certification from any state governmental agency that regulates any occupation or profession?
No, sir.
All right, now, you have certain constitutional rights, which I understand, before I can accept the plea of guilty from you. First, you have a right to have an attorney, and Mr. Kirk's been appointed to represent you. Now, he wasn't appointed simply to try to work the case out, but to provide any defense that could be available to you under the law that you would like him to provide. So if you decide you do not want to plead guilty, that you want to defend this case, he'll continue to represent you, including a trial, if that's what you want. Do you understand that?
Yes, sir.
All right, now under the Constitution, you have a right to have a jury trial in this matter, Mr. Cumberland, in which 12 people who live in Highland County, 12 people would be selected from a group of people that are residents of Highland County that are summoned for a jury duty on your trial date. After 12 members of that jury are selected, the evidence would be presented, they'd be instructed on the law by the judge, and then that jury would decide by unanimous verdict, meaning all 12 would have to agree, as to whether the state proved your guilt on the charge. If you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive, which means to give up, in writing, your right to have a jury trial, and in that case, you would have what's called a court or bench trial. And that means that instead of a jury hearing the evidence, it would be the judge would hear the evidence, the judge would apply the law, and the judge would decide whether or not the state proved your guilt. Do you understand that?
Yes, sir.
All right, and Mr. Cumberland, you have a right to confront witnesses against you and to cross-examine them in open court through your attorney. What that means is that the witnesses against you have to come into court and testify in front of you and your attorney and anyone else is present. After the prosecutor's done asking questions, your attorney asks questions. That's called cross-examination. And the purpose of that is to try to bring out evidence that helps your side of the case. Do you understand that?
Yes, sir.
Under the Constitution, Mr. Cumberland, you have a right to use the power of the court to compel or force witnesses to come into court to testify for you, just like the state. So if you have witnesses you're not certain are going to come in voluntarily, at your request, the court issues a subpoena, which is a court order that forces those people that you've named to come to court to testify if you want them to, even though they don't want to be here. That's the same way state's witnesses are forced to come to trial and testify against you. Do you understand that?
Yes, sir.
Under the Constitution, Mr. Cumberland, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can't, you make that decision. And if you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time. No one's even allowed to comment about it except in one situation. If there's a jury trial and you don't testify, The judge instructs the jury that because that's your right, they cannot consider it for any purpose. You understand that?
Yes, sir.
All right, now under the Constitution, you're presumed innocent of this charge until proven guilty by the state of Ohio on every essential element of that charge. So what that means is the burden of proof isn't on you to try to prove you're not guilty simply because you've been accused. In fact, under the law, you don't have to put on any defense at all at trial. You may, but you're not required to. But whether you do or not, the burden of proof will remain upon the state to prove your guilt by proof beyond a reasonable doubt, which is the highest burden of proof that's known under the law. And do you understand that?
Yes, sir.
Right now, under the Constitution, you entered a not guilty plea, and you denied all the allegations in the indictment, denied you committed any crime. And that exercised all the rights that I've just described. Now, if you change your plea today from guilty to not guilty, that is the opposite of the not guilty plea. The guilty plea admits the allegation in the indictment, admits that there's a crime, that you committed that crime. And that plea waives or gives up all of the rights I've described for you today, except the right to have an attorney, which you always have no matter what your plea. But without exception, your plea of guilty waives gives up your right to a jury or court trial. It waives gives up your right to confront witnesses against you and cross-examine through your attorney. It waives gives up your right to use the power of the court to compel or force witnesses to come to court to testify for you, the same as the state. It waives gives up your privilege against self-incrimination because you're saying you're guilty, that's what you find you guilty. It waives gives up your presumption of innocence because if you say you're guilty, the state doesn't have to prove you're guilty. It also waives gives up your right to file an appeal, except that if I sentence you the maximum sentence, you could file an appeal within 30 days of the sentence and enter being filed, and it does subject you to being sentenced immediately by the court. Now, do you understand all of that?
Yes, sir.
And are you a U.S. citizen?
Yes, sir.
Right now, do you have any questions about the charge and the possible penalties?
No, sir.
You understand?
Yes, sir.
Do you have any questions about the plea of guilty, what it means, or what will happen if you enter that plea here today?
No, sir.
Do you have any questions about the plea agreement?
No, sir.
You understand that?
Yes, sir.
Do you have any questions about the constitutional rights I've explained?
No, sir.
You understand that?
Yes, sir.
Now, I didn't tell you this at the beginning, but if you need to talk with your attorney, we can give you a time with him on the screen alone in a breakout room, and nobody else will be able to see you or hear you. Do you need to talk to Mr. Kirk about anything?
Yeah, I'd like to ask him one question if that's possible.
That's absolutely possible. Also, I neglected to do this at the beginning, but Mr. Kirk, you and your client both agreed to this matter being by Zoom rather than in person?
Yes, Your Honor.
Okay. And is that what you needed to talk to him about at all?
No, sir.
Are you okay with that? I mean, doing this by Zoom instead of coming up here?
Yeah, that's fine.
Okay, all right. Now what I'm going to do is put you into a breakout room, and there will be a button pop up here in a minute on the screen, and it'll say join the breakout room, and you click on that, and then it'll take you and him to a different screen, and you'll be talking confidentially, the deputy there stepping out. When that is done, you'll hit a button that says leave breakout room, and it'll kick you back where it'll say joining again, and you'll have to be readmitted. And when that happens, you can motion to the deputy that he can come back in.
Okay.
So I'm doing that right now. Okay. So it should be popping up there momentarily. Yep. Okay. All right. Now, Ms. Whit, after we're done with his case, we'll We're back on record. State versus Cumberland. Now, are we ready to go go forward, Mr. Kirk?
Yes, Your Honor.
Okay. All right. So you got all your questions answered there that you had, Mr. Cumberland?
Yes, sir.
Okay.
Thank you.
You have any other questions you would need to ask me about anything I've explained to you today?
All set.
Then is it your decision, Mr. Cumberland, to withdraw your not guilty plea and plead guilty to the charge?
Yes, sir.
All right. Then as to the charge in count 1, I should have said, that alleges that on or about April 26, 2021, Highland County, Ohio, you and Heather Trevette did knowingly sell or offer to sell methamphetamine, a Schedule II controlled substance, an amount equal to or exceeding bulk amount, but less than 5 times bulk amount, in violation of 2925.03A1 of the Ohio Revised Code, the charge of aggravated trafficking of methamphetamine, a third-degree felony, carrying possible prison term between 9 and 36 months in the increments provided by law, a fine of up to $10,000, a mandatory fine of $5,000, and a possible license suspension of 6 months to 5 years. How do you plead?
Guilty.
All right, the court finds on this day in open court, defendant was advised of all of his constitutional rights, made a knowing, intelligent, and voluntary waiver of the same pursuant to Criminal Rule 11. Pleas accepted and filed. Defendant is found guilty of count 1. Count 2 is dismissed. The court will go ahead and proceed with sentencing since there's a joint recommendation. I know Mr. Cumberland, I believe, has had previous convictions, so I'll go ahead and proceed with sentencing at this time. Anything from the state?
Thank you, Your Honor. We would ask the court to follow the joint recommendation. Would note that this is what his co-defendant received in her case for this charge, and he does have a prior criminal history, including prison time. So based on all of that, we would ask the court to follow the joint recommendation.
All right, Mr. Kirk.
Thank you, Your Honor. Would also ask the court to follow the joint recommendation. As the state mentioned, I believe this is what the co-defendant received. And then in this case, my client has cooperated and wishes to resolve this matter as soon as possible, so would ask the court to follow that agreement.
All right, Mr. Cumberland, is there anything you would like to say? You're not required to say anything, but I'll listen to whatever you have to say.
No, sir.
All right, well, you have cooperated and taken accountability for this offense, so the court will go ahead and sentence you pursuant to the plea agreement. It's ordered that you pay, or I'm sorry, it is judgment order of the court that you be sentenced to the Correction Reception Center at Orion, Ohio for a period of 12 months. According to Sheriff's Department, you were arrested on the 1st of February, is that correct?
No, I was arrested January 5th. I was brought here from Kentucky prison.
Oh, okay. You were in Kentucky January 5th? Okay.
Yep. I got here in Highland County Jail January 5th.
All right. All right, then that means that you have 89 days of jail time credit. Now, upon completion of this prison term, Mr. Cumberland, it is possible that the Adult Parole Authority will choose to put you under post-release control. That's their decision. It's optional, but we have nothing to do with it. If they do, you'll be supervised by a parole officer on the conditions they set for a period of up to 2 years. If during that period of time they determine that you have failed to comply, they could return you to prison, make you serve an additional period of up to 6 months for 1 or more violations. But if you committed a felony, then in addition, whenever sentenced a judge in a new case could impose upon you, the judge could also sentence you for committing that new offense, while under post-release control in this case, to an additional period of a year, or whatever time is left on that period of post-release control, whichever is greater. If that occurs, that has to be served consecutively to the sentence in a new case. You're also ordered to pay court costs, which judgment is granted and execution is ordered. If you fail to do that, the court could require you to do, well, first of all, the clerk could try to collect that through various means, including levying on bank accounts, wages, earnings, commissary account, or any other assets you may have. If that doesn't collect it, then once you get out of prison, you can do community service and be given credit for each hour you worked in an hour rate set by the court, and each hour you worked will reduce your judgment by that amount, and that would have to be in this county. You're also ordered to pay restitution, the amount of $220 to the Highland County Task Force through the Highland County Victim Witness Office, and pay the $5 or pay whatever the service fee is for those payments. Now, have you had any change in your financial circumstances since I appointed Mr. Kirk to represent you?
I didn't hear you, sir.
Have you had any change in your financial circumstances since Mr. Kirk was appointed? All right, then the court will find you don't have the ability to pay the mandatory fine, and that will be waived. All right, is there anything further from council?
Judge, did you say 62 days of jail time credit?
No, 89. Yeah. Originally I said 59, but he had the additional time from Kentucky. All right, anything further?
No, sir.
All right.
No, Your Honor.
You're remanded to custody. All right, now, Mr. Armentrout, I can go ahead and create this breakout room. Okay, we have two cases involving same defendant, Thomas J. Parks. Case number 22 CR 220, State of Ohio versus Thomas Jeffrey Parks, and 22 CR 49, State of Ohio versus Thomas J. Parks. Mr. Parks is appearing by video from the Justice Center. You are Thomas J. Parks?
Yes, sir.
All right. His attorney is Danielle Witt, appearing from her office. Appearing from the prosecutor's office is Annika Collins, prosecuting attorney. This hearing is being conducted by Zoom. Mr. Parks has returned for this hearing. I believe this is a final pretrial. In case number 22 CR 220, he's charged with failure to appear. And in 22 CR 49, he's charged with failure to comply with order to signal a police officer. And I believe we have a trial date on this case of, we'll find it here. March 23rd. All right, now where do we stand on this case, counsel?
Your Honor, since he has been incarcerated, if I could have a couple more days to discuss his case with him, I believe that we'll have resolution.
Okay.
However, the trial date it would fall 13 days after Friday, so.
We could wait till
have
Monday.
an exception.
Yeah.
Do what?
I said we could have a hearing Monday. Are you available Monday?
I am. We need to vacate the jury trial date.
Yeah, well, if there's going to be a plea, but let's just go ahead and we'll wait. We can wait till Monday and by noon, and then if we get a resolution, then we won't have to send out jury notices. Otherwise, we'll go forward.
Okay, I'm available in the afternoon on Monday.
Okay. Monday.
What about Friday morning?
Pardon me?
What about Friday morning?
Drug court. Oh no, what time are we doing drug court? Oh,
We're doing it
okay.
12:30, but
That's
I
right.
have
We only have a half day drug court.
You
Would
have
you be
a
available
long-
Friday morning?
After,
She's here at 9:15.
yeah, I'm here at 9:15, so
All right.
after
For
that.
who?
Irving has what's indentured, but look, you got that too. We have these bond reviews at 8:30, then we have that at 9:15. Those won't take very long.
I've got a bond review at 8:30. I've got a meeting at 10 that I got to get to. So how about 8:45?
That'll work.
Pardon me?
That will work, Your Honor.
All right, 8:45. All right.
Who's this one?
Thomas Parks. So we'll continue this till then, and then tell them to hold off on the jury notices until Friday.
Okay.
Okay, thank you.
Thank you.
All right, you have anyone else, Miss Witt?
I do, Jamie Markham
All right.
and Michael Newsom.
Are they in jail?
Yes.
Filed a motion to dismiss Michael Newsom.
Oh. All right, yeah, Newsom's dismissed, and so
Also,
the other
we
one.
have Shane Rhodes. Is he supposed to be seen? He's on our list right now.
Yeah, I'm trying to get to Miss Whitson counsel.
We did Shane Rhodes yesterday.
Pardon me?
Shane Rhodes we did yesterday, Monday.
Yeah, he's gone. Yeah.
Markham.
Okay.
do it.
All right, are you Jamie Lee Markham appearing there from the jail?
Yes, sir.
All right, this is case number 22. Jamie Lee Markham. Mr. Markham is charged with assault on a peace officer, 4th-degree felony. This is a final pretrial, I believe, and a trial is set for March the 23rd. Now, Mr. Markham is appearing from the jail. His attorney is Danielle Witt, appearing from her office, and appearing from the prosecutor's office is Prosecuting Attorney Collins. Ms. Witt, do you and your client both agree that this matter can be conducted by Zoom remotely rather than appearance in the courtroom personally?
Yes, we do.
You're all right with that, Mr. Markham?
Yes, thank you. Yes, sir.
All right, now, Mr. Markham, I've been presented with a plea of guilty form which says you're going to withdraw your not guilty plea of guilty to the charge. Excuse me. It's first page. I'm going to hold up the camera. It has your name and address, charge. Let's turn it the wrong way. Has your case number, your name, and plea of guilty form. You recognize that form?
Yes, sir.
On page 3, there are signature lines. About a third of the way down the page, there's a sentence that reads, "Enter this plea voluntarily," and right below that appears to be Jamie L. Markham. Is that your signature that I'm looking at there?
Yes, sir.
When did you sign this document, Mr. Markham?
Today, sir.
And when you signed it, did you understand it was an agreement to plead guilty, which means there won't be a trial, and the next step would be a sentencing hearing?
Yes, sir.
And did you go over this with your attorney and have her answer any questions, explain everything to you before you signed it?
Yes, sir.
And when you, do you think you had enough time to fully consider the matter before making this decision?
Yes, sir.
And is it your choice to go forward today and plead guilty pursuant to the terms of this agreement?
Yes, sir.
And you signed this agreement voluntarily?
Yes, sir.
Right now, the first page indicates you're going to plead guilty to the charge of assault on a peace officer, 2903.13a, 4th-degree felony. Further states you understand maximum prison term that could be imposed for that is 18 months, minimum would be 12. There could also be a fine of up to $5,000. You understand that?
Yes, sir.
And are you facing any felony charges in any other jurisdiction?
No, sir, I am not.
Are you currently on probation, parole, community control, or post-release control for a felony?
No, sir, I'm not.
Now, under the law, Mr. Markham, if you should be sentenced to prison for commission of this offense, once you complete the term imposed, the law provides that the adult parole authority could decide to put you under post-release control supervision for a period of up to 2 years. That means, oh no, wait a minute. Oh yeah, this is not a 3rd degree, okay. So it could be for a period of 2 years. If during that period of time, the parole authority decides that you have failed to comply with the conditions they set, it could return you to prison for a period of up to 1/2 of the prison term that was imposed for one or more violations. However, if there's a new violation or a new felony committed, then in addition to whatever sentence a judge in that new case could impose upon you, the judge could also sentence you for committing that offense while under post-release control in this case to an additional period of a year, whatever time is left on that period of post-release control, whichever is more. And if that occurs, that must be served consecutively sentence in the new case. Do you understand that?
Yes, sir.
Now, I'm not required to sentence you to prison for this offense. I can impose what's called community control or probation, which means you'd be supervised for a period of up to 5 years by the probation department under terms set by the court. If during that period of time they felt that you weren't complying, they would file written notice of that with the court. There would be a hearing. You'd have the right to have an attorney. If the outcome of that hearing was that you'd failed to comply, then at that time the court could revoke your community control and then sentence you to prison for 18 months and fine you $5,000. Do you understand that?
Yes, sir.
Right now, the charge alleges that on or about November 3, 2022 in Highland County, Ohio, that you did knowingly cause or attempt to cause physical harm to Patrolman Mark Hamilton, a peace officer defined in ORC 2935.01, while in the commission of his official duties in violation of 2903.13a. So that's the charge of assault on a peace officer fourth-degree felony with a prison term of 6 to 18 months and a fine of $5,000 possible sentence. Do you understand what it is you're charged with, what the state said you did, when, where, and how they alleged you did it?
Yes, sir.
You understand the possible penalties for the offense?
Yes, sir, I do.
Now, have you discussed the nature of the charge, the evidence in the case, possible legal issues in the case, possible defenses you might try to raise at trial, and possible outcomes of a trial with your attorney?
Yes, sir, I am.
Are you satisfied with her advice and competence in this matter?
Yes, sir, I am.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir, I'm not.
The agreement states on page 2 that you, in two bold lines that are printed there and underlined, defendant shall enter a plea of guilty to the indictment. State and defense jointly recommend community control, substance abuse treatment, and/or mental health counseling. That's your understanding of the agreement.
Yes, sir.
Does anyone promise you anything other than that to get you to plead guilty here today?
No, sir.
Now, under the law, the recommendation is to sentencing is not binding on the court. So if you plead guilty, the judge does not have to follow that recommendation. I could decide, after all the evidence is presented, that that's not the correct sentence. Could end up sentencing you to prison if I thought that was appropriate for up to 18 months. Do you understand that?
Yes, sir, I do.
Do you hold any license or certification from any state governmental agency that regulates any occupation or profession?
No, sir, I don't.
Now, under the law, you have certain constitutional rights, you must understand, before I can accept your plea. First, you have a right to have an attorney. I appointed Ms. Witt to represent you, not simply to work the case out, to provide any defense that might be available to you under the law that you wish her to provide. So, if you decide you don't want to plead guilty, that you want to defend against the charge, she'll continue to represent you, including a trial, if that's what you want. Do you understand that?
Yes, sir, I do.
All right, now under the Constitution, you have a right to have a jury trial in this matter, in which 12 people would be selected from a group of citizens that are summoned for jury duty on your trial date. Those people would all live in this county. After they are selected, 12 of them, then there would be evidence presented, and the judge would instruct them on the law. And then that jury would decide by unanimous verdict, meaning all 12 have to agree, on whether the state proved your guilt. Now, you didn't want to have a jury trial, but you didn't want to plead guilty. You can waive in writing, which means you give up the right to have a jury trial. In that case, you would have what's called a court or bench trial. And that means that instead of the jury hearing the evidence, the judge would hear the evidence, the judge would apply the law, and the judge would decide whether or not the state proved your guilt. Do you understand that?
Yes, sir, I do.
Now, under the Constitution, Mr. Markham, you have a right to use the power of the court to compel or force witnesses to come into court to testify for you, just like the state. So if you have witnesses you're not certain going to come in voluntarily, at your request, the court issues a court order, it's called a subpoena, and that forces those people to come to court to be able to testify if you want them to, even though they don't want to be involved, which is the same way the state's witnesses are forced to come into court to testify against you. Do you understand that?
Yes, sir, I do.
All right, now, under the Constitution, you have a privilege against self-incrimination, which means that you cannot be compelled to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can't, you make that decision. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time, and no one's even allowed to comment about it, with one exception. If there's a jury trial and you don't testify, the judge instructs the jury that because that's your right, they cannot consider it for any purpose. Do you understand that?
Yes, sir, I do.
Right, under the Constitution, you're presumed innocent until proven guilty by the state of Ohio on every essential element of the offense charged. What that means is that you're not required to try to prove your innocence simply because you've been accused. In fact, under the law, you're not required to present any evidence in your own defense at all. You may, but you're not required to. Whether you do or not, the burden of proof will remain upon the state of Ohio to prove your guilt by proof beyond a reasonable doubt on every essential element of the offense charged, which is the highest burden of proof that's known under the law. Do you understand that?
Yes, sir, I do.
Now, originally you entered a plea of not guilty, and that plea denied the allegation in the indictment, denied you committed any crime, and it exercised or invoked all the rights that I've just described. If you change your plea from not guilty to guilty, that is the complete opposite of the not guilty plea. The guilty plea admits the allegation in the indictment, admits that they're a crime, that you committed that crime. That plea waives, gives up all the rights that I've just described for you, except the right to have an attorney. You always have a right to have an attorney no matter what your plea. With that exception, your plea of guilty would waive, give up your right to a jury or court trial, would waive, give up your right to confront witnesses against you and cross-examine through your attorney, would waive, give up your right to use the power of the court to compel or force witnesses to come to court to testify on your behalf, the same as the state. It would waive or give up your privilege against self-incrimination because you're saying you're guilty, and that's what you used to find you guilty. And it would waive or give up your presumption of innocence because if you say you're guilty, the state doesn't have to prove you're guilty. It also subjects you to being sentenced immediately by the court And finally, it waives gives up any right to file an appeal you think you may have had up until this point in the case. Now, if you change your plea from not guilty to guilty, that's the complete opposite of the not guilty plea. The guilty plea admits the allegation in the indictment, admits that they're a crime. It admits or waives your right to a jury or court trial. It waives the right to confront witnesses and cross-examine your attorney in open court. It waives and gives up your privilege against self-incrimination, and waives and gives up your presumption of innocence. And again, as I said, subjects you to being sentenced immediately by the court. Now, you understand all of that?
Yes, sir, I do.
And are you a U.S. citizen?
Yes, sir, I am.
Do you have any, okay, you have any questions then about any of the things that I've explained to you here today?
No, I do not.
Is there anything you need to speak to your attorney about?
No, there is not.
And you understand the plea agreement and that it's not binding on the judge?
Yes, sir.
And you understand the consequences of your plea here today if it's guilty?
Yes, sir.
Okay. Then is it your decision to withdraw your not guilty plea, plead guilty to the charge pursuant to the terms of the plea? Is it your decision you're going to plead guilty according to your plea agreement?
Yes, sir.
Then as to the charge which alleges that on or about November 3, 2022 in Highland County, Ohio, that you did knowingly cause or attempt to cause physical harm to Patrolman Mark Hamilton, peace officers defined in ORC 2935.01, on commission of your official duties in violation of 2903.13a, a fourth-degree felony carrying possible prison term between 6 and 18 months and a fine of $5,000 out of your plea.
Yes, sir.
Right, the court finds on this day in open court, defendant was advised of all his constitutional rights, made a knowing, intelligent, voluntary waiver pursuant to Criminal Rule 11. Please accept the order filed. Defendant is found guilty of the charge as set forth in the indictment. Court will order a pre-sentence report, including an assessment for possible substance use and/or mental health disorder treatment. Sentencing will be April the 5th at 9 a.m. Bond is continued. Anything further from counsel?
No, Your Honor. No, Your Honor.
All right, thank you. All right, Michael Newsom is next.
Judge, we filed a motion and you signed the entry to dismiss Michael Newsom.
Oh, that's right. All right. Yeah, it didn't go down. The file didn't get pulled. All right. You have anyone else, Miss Witt?
Nope, not until.
All right, case number 23 CR 12, State of Ohio versus Cassie Brigner. This is a Zoom hearing being conducted. Ms. Brigner's appearing. And are you, Ms. Brigner, on the screen? It says KingPad /SA8.
Yes.
All right. And this hearing is being conducted by Zoom. Her attorney is William Armentrout, appearing from his office. Appearing from the prosecutor's office is Prosecuting Attorney Collins. Defendant is charged in a 13-count indictment. In the first 12, there's a co-defendant, Richard Wayne Johnson, most serious of which is engaging in a pattern of corrupt activity. This is a final pretrial. We have a trial set on April the 10th. All right. Where do we stand on this case, counsel?
Your Honor, we've had, I was able to speak to Cassie, as the court's aware, a little bit ago. She's had, I know she's had transportation problems to get to my office, although I believe she is compliant with pretrial, and spoke with her mother also. She will be in my office at 2 o'clock tomorrow, Your Honor. I've had ongoing negotiations with the prosecutor. We do believe the matter resolves itself through plea, so the trial date's still a couple, 3 weeks away, so we're not going to ask to continue anything at this point in time. Very serious charges, but I think we will get it resolved.
All right. All right, we don't have anything scheduled until your trial date of April 10, Ms. Brigner, but if, keep in touch with your attorney, because if you do get something worked out, we'll be bringing you in a couple of weeks beforehand. And since that's the court's deadline, that'll be about the last week of March. No later than that, 26th or 27th, whatever that date is. All right. Anything else, counsel? All right. Let's see. I think we're done with you then, Mr. Armentrout?
No, I've got a 2 and a 2:30, Judge.
Oh, okay. Let's see, your 2 o'clock is, who? Oh, who? Oh, Hogsett, okay.
Yeah.
And, all right, well, we don't have anyone else. You can go ahead and sign off there, Ms. Brigner. Thank you.
All right, thank you.
Your Honor?
Yeah.
Mr. Hogsett signed in to do court here, but then he was worried about how he just took off.
He's worried about what?
So he was worried about being late since it was getting close to 2 o'clock. So
Oh,
he left
okay.
before I could.
Oh, he just walked in the courtroom. All right. Mr. Hogsett, we actually had your hearing set up by video, but we'll go ahead and do it. Just have a seat right there. Your attorney is on the screen here, and so is the prosecutor. So you should be able to hear everything, all right? All right, case number 23 CR 5, State of Ohio versus Jeremy Hogsett. Mr. Hogsett is present in the courtroom. This was actually set for a pretrial. We were going to do it by Zoom, but he came up from probation. Office by Zoom is Annika Collins. Defendant's charged with grand theft and tampering. I believe this is a first pretrial, and we have a final pretrial on April 5 and a trial date of April 27. See, the state provided discovery and requested discovery, and also bill of particulars was provided. And have you done your discovery yet, Mr. Armentrout?
Yes, Your Honor, March 2.
Okay. All right. And did you file any pretrial motions yet?
No, there wouldn't be any.
Okay. And has there been a written plea offer received, Mr. Armentrout?
There has, Your Honor.
Is your client aware of that yet?
No, he's not, Your Honor.
All right. You want him to get in touch with your office to make an appointment?
If you can, Judge, I need a phone number for him and for him to call my office immediately to schedule an appointment.
All right. What's a good phone number for you?
937-661-0871, Your Honor.
Did you get that, Mr. Armentrout?
6610871.
Yeah. All right. And why don't you just go ahead and walk down to his office now and get an appointment?
Okay.
It's locked, Your Honor, because I'm the only one.
Oh, okay. Well, all right. You just want to call him there in a little while, or?
He should know how to get hold of me. He can call me and set up an appointment.
All right. Well, yeah, you got a break until
2:30.
2:30. All right. So just go ahead and give him a call then when you leave.
Okay.
All right. Well,
Yes, sir.
and on the next hearing, we can do it by Zoom if you're available. If you got a phone or a smartphone or a laptop or something, or otherwise, let your attorney know. We'll do it in person.
Yes, Your Honor.
All right. Thank you. You can go. All right, case number 23 CR 009, State of Ohio versus Rhonda Patricia. And you're Rhonda Sue Patricia appearing there on the screen with your name?
Yes.
All right. Ms. Patricia, this is a Zoom pretrial. Ms. Patricia's attorney is Dennis Kirk, appearing from his office, appearing from the prosecutor's office as Prosecuting Attorney Collins. Defendant's charged with election falsification, possession of false records. This is a first pretrial, first pretrial. Final pretrial is March 22, and the trial is April 10. I see that the state has provided discovery and a bill of particulars. And you received that, Mr. Kirk?
Yeah, we have received it, Your Honor.
And have you filed yours yet, or you?
I have not yet, Your Honor.
Okay, it'll be due by final pretrial. Are you anticipating any pretrial motions?
Not at this time, and I believe we'll have a resolution, be contacting the assignment commissioner to set a plea hearing.
Okay. All right. Any other matters we need to discuss?
Not at this time that I'm aware of.
All right.
No, Your Honor.
All right, thank you. Okay. I see Mr. Camp. Ms. Barger, Mr. Purdon case was dismissed, so he did show up here, and I gave him the good news. Sorry about that, but he was happy. So, all right. Case number 22 CR 238, State of Ohio versus Dylan Tate Campbell. And you're Dylan Tate Campbell, appearing on the screen there. Mark Dylan Campbell.
Yes, sir.
All right. This is a Zoom pretrial. Mr. Campbell is appearing, as I indicated, by Zoom. His attorney is Sarah Barger, appearing from her office, and appearing from the prosecutor's office is Prosecuting Attorney Collins. The defendant is charged with aggravated possession of methamphetamine, a fifth-degree felony. This is a first pretrial, actually final pretrial, and trial set for March 23. Now, where do we stand on this case, counsel?
Your Honor.
Go ahead.
I'm sorry, go ahead. I believe that Ms. Barger was going to ask for a continuance, and she's contacted me. We've talked about this case, and we agreed to the continuance in an effort to get both cases resolved at once. I do know that Mr. Campbell has recently been in the detox, so I'm not sure how much communication Ms. Barger has been able to have with him. So based on all of that, we would not object to a continuance.
Is that what you're about to say, Ms. Barger?
It was.
All right. There's another case. Is that in this court?
Yes.
Okay. It didn't get on for today, apparently. What's that case number?
On the 22nd.
What's the case number?
23 CR 0036.
00 what?
36.
Thank you.
It's set for the 22nd.
All right. Well, let's just continue this till the 22nd.
Perfect.
And you're requesting a continuance of this case. So we'll do that. We'll continue for a pretrial to the 22nd and a trial date of April the something. April the 13th then. All right. Well, I don't know. What's the other case? Is it a drug case as well?
It is, and its trial date is the 24th.
Is it one that could be tried jointly if the state requests that?
Probably not.
Okay. All right, then the trial will be continued. Pre-trial will be set for March 22. Is that one set at 2 o'clock or something like that? Do we know?
It's at 1.
Okay. Well, we'll make it 1 o'clock by Zoom, and the trial date will be April 5 at 8 a.m. Oh, wait a minute, that's not a trial date, April 10. I wondered about that. I didn't think that was a trial date. All right. So the speedy trial time is extended pursuant to 2945.72H of the Higher Revised Code. So you won't have to worry about the 23rd, but we will see you again on the 22nd by Mr. Campbell. You're still there in the detox there at Foundations?
Yes, sir. I think I'll be in discharge tomorrow.
And where will you be going?
Outpatient until, I got a report from the probation. They told me to call them as soon as I get out.
Right, okay. All right, I'll just make sure you do that. All right, anything else council wish to discuss?
No, Your Honor.
All right, thank you.
He just needs to call me when he gets out as well.
I will.
All right, Jennifer Baker. All right, case number 23 CR 29, State of Ohio versus Jennifer M. Baker. This is a pre-trial by Zoom. Miss Baker, you're appearing there on the screen from the Highland County Probation Department, HCPD.
Yes, sir.
All right. Ms. Baker's attorney is James Bolger, appearing from his office. Appearing on behalf of the state is Prosecuting Attorney Collins. The defendant is charged with felonious assault, aggravated assault, and a forfeiture specification. I believe this is our first pretrial, our final pretrial set for April 5 at 2 p.m., also by Zoom, and then April 27 for the trial. See, the state's provided a bill of particulars and discovery. Mr. Bolger, yours will be due by the final pretrial. Do you anticipate any pretrial motions?
I do not.
Okay. Well, if you do have any, those will be due by final pretrial as well. And has there been a written plea offer received?
Yes, Your Honor, there has. So we've reviewed it, and we have not accepted it.
Okay. All right. Well, if there's no agreement by the final pretrial, we'll need to have her sign a written rejection and you keep a copy and the state keep a copy.
Yes.
Now, any other matters that council wishes to discuss at this time?
Not from the state.
Mr. Bolger?
Your Honor, there are a few items. I'm not sure whether they're within the scope of discovery. In this situation, there was a phone call made by my client to the Sheriff's Department as the incident was transpiring. I don't know whether it was reported. If it was, it hasn't come through in discovery. I'm not sure whether that was a 911 or not.
Well, if he wants it, he can contact the sheriff's office.
Okay.
It is public record, yeah.
Okay.
Okay.
The other two items I think fit into the same category. There was also a question in my mind as to whether shotgun shells were recovered from Jennifer's property on Walnut Shade Road.
Well, you need to address that to the prosecutor outside of this hearing. I'm not gonna be a playground monitor here. Anything else?
No.
All right. Well, then April the 5th will be your next pretrial, Ms. Baker. Stay in touch with your attorney. All right, thank you. You can go ahead and sign out, ma'am, or leave. I don't know if we got anybody else over there or not.
staff changes in our office.
You have filed it.
Oh, my apologies.
Somebody is looking after you. When was it filed? Last week? I don't have it here.
I don't see my stuff.
We received a copy of it, today.
Okay, then it must be downstairs. Okay.
Thank you, Ms. Collins.
All right, this case number 23, CR 11, State of Ohio versus Richard Wayne Johnson. You're Richard Wayne Johnson, appearing there from the probation department. Excuse me. All right, this hearing is being conducted by Zoom. Mr. Johnson's attorney, Catherine Memzik, is present from her office, and present on behalf of the state from her office is Prosecutor Collins. Defendant is charged in 12 out of 13 counts in the indictment with a Cassie Brigner, including engaging in corrupt activity and various other charges. This is a first pretrial.
This is a final, Judge.
Oh, this is final pretrial? All right. So we have a trial date of April 10. All right. Now, have you got the discovery from previous counsel?
Yes, Your Honor.
She was with your firm?
Yes, Your Honor.
Okay. And I don't see that you filed your discovery yet, have you?
No, Your Honor, we would be requesting a continuance today of both the final pretrial and the trial date. An offer has been given to us by the state. We would just like an opportunity to have a meaningful discussion with our client.
All right. Well, we'll continue this in progress. I'm not going to continue the trial date at this time because that's over a month away. So what about March the 22nd, 2 weeks?
Yes, Your Honor.
Right? So we'll continue this till March the 22nd at 2:30, and it'll be by Zoom.
Thank you, Your Honor.
Yeah. All right. Now, any other matters to, you don't have any pretrial motions you're filed yet, but I'll extend your time to do it to that date as well. All right.
Thank you.
Anything else from counsel?
Not from the state.
All right.
No, Your Honor, thank you.
Okay, then Mr. Johnson, stay in touch with your attorney, discuss the developments in the case, and we'll have another session in 2 weeks. If you don't have access to your own computer, just go to the probation department or your attorney's office. You may want to do it, go to your attorney's office that day, but I'll leave that up to you guys to coordinate. All right? Thank you. You go ahead and sign out. Case number 23 CR10, State of Ohio versus Michelle E. Stant. And you're Michelle E. Stant, appearing from the probation department on the screen there. Can you hear me, Ms. Stant?
Yes.
All right. Can you hear Ms. Stant appearing on the probation department screen?
Yes.
All right. This hearing is being conducted by Zoom pretrial. Ms. Stant's attorney is Catherine Hapner, appearing from her office. Appearing from the prosecutor's office is Prosecutor Collins. Bennett is charged with election falsification and possession of false records. This is the first pretrial. Final pretrial is on March 22. Trial date is April 10. See that the discovery has been provided. And defense has provided discovery as well. Did you file any pretrial motions, Ms. Hapner?
No, Your Honor.
Do you anticipate any?
I do not.
And are there any other discovery matters that need to be filed to either party's knowledge?
I don't believe so.
Has there been a written plea offer received?
There has. I have not yet gone over that with my client, but I anticipate that we'll have an opportunity to discuss it next week.
Okay, she has an appointment?
She needs to come in and see me, so
Okay.
hopefully she will do that.
All right, Ms. Stant, you need to get a hold of Ms. Hapner's office right away, first thing in the morning, and get an appointment to talk to her before your next hearing.
Okay.
The next hearing is in 2 weeks. We'll do it by Zoom as well. Either you can go to the probation department, or if Ms. Hapner wants you to come to her office, whichever is easier for the two of you. Okay? Thank you.
All right. Thank you. Thank you.
All right, Joseph Glenn Blanton. Well, we're back on schedule. We're doing pretty good today. Well, we didn't have the clerk blow up our schedule this morning. I'm going to have a talk with them after I get done here. All right. Case number 23 CR 16, State of Ohio versus Joseph Glenn Blanton. And you're Mr. Blanton, appearing on the screen for the probation department?
Yes, ma'am. Or sir, I'm sorry.
Okay. No problem. This is a pretrial by Zoom, and Mr. Blanton's attorney is Dennis Kirk, appearing from his office. Appearing from the prosecutor's office is Prosecuting Attorney Collins. The defendant is charged in a 3-count indictment, 1 count of aggravated trafficking in a fentanyl-related compound, 1 count of aggravated possession of the same, 1 count of aggravated possession of methamphetamine. This is a first pretrial. Final pretrial is in 2 weeks, March 22, and trial set for April 10th. Now I see that state provided a bill of particulars and a discovery, and you received that, Mr. Kirk?
I have, Your Honor.
All right, your discovery will be due by the final pretrial. Do you anticipate any pretrial motions?
And not at this time.
All right, and has there been a written plea offer?
Yes, Your Honor.
And I have relayed that to my client.
Okay. Are there any other matters that need to be discussed at this time?
Not from the state.
Not at this time.
All right, then we'll be back 2 weeks from today. You can go to the probation department there for the Zoom, Mr. Blanton, or talk to your attorney about, if he wants to be with you in the same room, we can work that out. Whatever you guys want to do will work out fine. All right, thank you. All right, we need CR7, State of Ohio versus Alyssa D. Young. You are Alyssa D. Young, appearing from the probation department on the HCBD screen.
Yes, Your Honor.
All right. This is a pre-trial by Zoom. Ms. Young appearing from the probation department, appearing on behalf of the state or defendant is attorney Sarah Barger, and appearing also on behalf of the state is prosecuting attorney Collins. Defendant is charged with aggravated possession of methamphetamine, a 5th-degree felony. This is a first pretrial. Final pretrial is March 22. Trial date is April 13. Looks like the state's provided discovery as requested and a bill of particulars. Have you done your discovery yet, Ms. Barger?
I have, Your Honor.
Okay. Do you anticipate any pretrial motions?
Not at this time.
All right. And have you received a written plea offer?
I have, Your Honor.
Is your client aware?
She is not. She hasn't contacted me until today. I will set up an appointment to go over that with
Right.
that.
You do have an appointment to see her then?
She needs to make one.
All right. Stay in touch with your attorney then, because you'll need to be talking about these developments in your case, Ms. Young, and we'll have another pretrial by Zoom on the 22nd. And if you're not able to, do that yourself, then go to the probation department again. All right?
Thank you, Your Honor.
All right, thank you. You can go ahead and leave.
All right, thank you.
Number 23, CR006, State of Ohio versus Joshua Allen Barger. Mr. Barger is appearing by Zoom on the screen that's marked 7NEVU. His attorney is Sarah Barger, appearing by Zoom from her office, and appearing on behalf of the state is prosecuting attorney Collins.
His attorney is Danielle Witt.
Oh, I'm sorry. I thought I saw Barger on there. Oh, no. Well, Miss Witt's not here. Is she? Oh, yeah, there she is. Sorry about that. Miss Witt, would you log on? You're muted there, ma'am. Miss Hapner. Okay, you're coming into focus now.
Yeah. She's actually in juvenile court at the moment, so she asked me to cover this for her.
Okay, we'll let that happen since it's a pre-trial hearing. Hapner for Witt. Okay. Now, Mr. Barger's charged with aggravated possession of a fentanyl-related compound, and I have received a copy of the stipulated questions for intervention. And has that motion actually been filed?
It was filed on February the 15th.
Okay. Well, I don't have it, but given what's been going on the last few days, I'm not surprised. There's been some real issues and some filing going on downstairs, so we'll have to see if we can find that. Oh, wait a minute, here it is, in one of the red folders that just came up. Yeah, we just got this today, even though it was filed on the 15th of February. All right, so Mr. Barger, this indicates that you're going to request to be considered for treatment in lieu of conviction, and is that all the answers that you signed these answers, they're all true, is that correct?
Yes, sir.
And are you in treatment today yet, or
yes, sir.
You're at Ed's place?
Yeah.
All right. Well, one of the things that this will do for you, if you're successful, will be you'll be able to avoid a felony conviction, but you have to be in treatment. So, you need to be staying there. So I'm going to refer you to the probation department for evaluation, and we'll get your evaluation from Ed's place. You'll need to sign a release of information so they can give Mr. Arjima all the information. And we will set this for a hearing. Let's see, what's the trial date, April 10?
No, it's March 28th, I think.
So March 28th, all right.
Yeah, March 28th.
Okay, what I'm going to do then is I'm going to vacate the trial date. We'll set a TIL hearing for April 5th at 9 a.m. No, make it 10 a.m. So you won't have to be here on the 28th. Now, again, Mr. Barger, one of the requirements in this is that you be in treatment for at least a year and comply with the conditions of not testing positive for any illicit substances. So, you know, I know that you were in treatment earlier, outpatient, and then they sent you to Ed's place, and it appears you went voluntarily, but you need to stay there and make sure you participate, because if you don't participate in a program like this, then you don't get the benefit of that. Okay?
Yes, sir.
So, we'll do the TIL hearing by Zoom and send the link there to Recovery Council and your attorney. And stay in touch with your attorney and probation. All right, anything further?
No, Your Honor.
All right, thank you. One.
Did she give you 5 questions?
Not yet, Andrew.
Okay, case number 22, CR 231, State of Ohio versus Jacob McComas. You're Jacob McComas appearing there from Southern Hope Recovery?
Yes, Your Honor.
All right. And Mr. McComas' attorney is Sarah Barger, appearing by Zoom. Also appearing by Zoom is Prosecuting Attorney Collins. Defendant is charged with breaking and entering and theft and aggravated possession of methamphetamine. There's been a motion for intervention in lieu of conviction filed. Have you filed the stipulated questions yet?
Not yet, Your Honor.
All right.
I can get this back to
All right.
the Recovery Center.
Okay. Well, this is set for final pretrial in 2 weeks, so and trial's not to April 13th. So I'll go ahead and order the TIL report. We will need the questions, and we will set this for a hearing on set it for March 5th.
Judge,
Yeah,
April?
April?
April 5th.
You said March the 5th?
I'm sorry, April the 5th.
Okay.
All right, I'll vacate the trial date of April 13 and reschedule it April 27. You'll need to let the folks there know that what you're doing there, Mr. McComas, and sign releases of information so they can give that to the probation department to be used in this report. Okay? Anything further from counsel?
No, Your Honor.
All right.
No, Your Honor.
Thank you. I can see you, Mr. Johnson, but says they're still connecting to the audio. Yeah, he's having some pixel problems there. Well, it looks like his signal's gone because he's frozen.
Here he comes back.
Yeah, but he's not got a very good signal. Can you hear me, Mr. Johnson? You apparently have a weak Wi-Fi signal there, Mr. Johnson. Your screen keeps freezing here. And it says you're connecting to audio. Mr. Armentrout 1, are you here tomorrow?
I'm with the magistrate at 11 o'clock, Your Honor.
Is that a pretrial?
No, it's a final hearing.
Okay.
Only scheduled for an hour.
What about 10:30?
Yeah, I've got my people coming in.
Oh, okay.
For that hearing.
I don't know what my schedule is either.
We have a few hearings in the morning. And then we have a few hearings in the
Mr.
afternoon.
Johnson, can you hear me? No. All right, I'm going to continue this case and then make it in person.
Says he can't hear anything, Your Honor.
I know his signal's no good. I can tell that.
Yeah, they're trying to get a hold of you.
Well, if he'd have been at your office, it wouldn't have been a problem.
Tomorrow?
Let me see. Bill's got 10. He's got a hearing at 11. What do we got at 1 o'clock?
It's an evidentiary. That's 3 judicial release videos from the institution.
Okay.
And that's an arraignment from the Fayette County Jail.
Oh, crap. All right.
How long will 3 videos take?
Oh, wow. And we need to do those first. We better tell them this will be second. What about 9 o'clock, Mr. Armentrout?
Yeah, I can do that, Judge.
All right, Mr. Johnson, this case is being continued until 9 a.m. tomorrow. Come to the courthouse. Since you didn't report to the probation department, we can't, your signal's not good, we can't get you. So hearing will be tomorrow, March the 9th at 9 a.m. And Mr. Arjima, would you tell him that, please? Well,
I am, Your Honor.
All right.
So tomorrow.
All right, counsel, thank you.
Thank you.
Okay, are you Roger Allen Fillmore? Okay, we don't have your volume up. I can't hear you. Lieutenant, if you can adjust the volume there, please.
Can you hear us now?
Yeah, it's good now.
Yes, sir, I am Roger Allen Fillmore.
Okay. This is case number 22 CR 236, State versus Roger Allen Fillmore. Mr. Fillmore, you were indicted by the grand jury back on December the 6th for aggravated trafficking of methamphetamine and aggravated possession. Count 1 alleges that that offense occurred on or about May 6th of 2022 in this county, and that you knowingly prepared for shipment, shipped, transported, delivered, prepared for distribution methamphetamine, which you knew was intended for resale. That is a 4th-degree felony, carries possible prison term if convicted between 6 and 18 months, possible fine of $5,000, possible license suspension 6 months to 5 years. Count 2 alleges on or about the same date, time, and place that you knowingly possessed methamphetamine. That's a 5th-degree felony, which carries a possible prison term if convicted of between 6 and 12 months and a fine of $2,500, and both carry possible license suspension of 6 months to 5 years. Now, you're entitled to counsel, Mr. Fillmore, and if you can't afford to hire counsel, the court will appoint one for you, and I see you filled out a financial disclosure form. Is everything on the form correct?
To my knowledge, yes, sir.
Okay. Now, we only have the front page, Lieutenant. I know you're having some fax issues, so apparently we are too. So when you get a chance, if you could fax up the back page.
Yes, sir.
When's the last time you're employed, Mr. Fillmore?
I'm self-employed, but I've been down and I don't have no equipment or no tools to do the work that I do, and so I mean it's been probably before Christmas was the last time I worked.
All right. The court will find you are entitled to appointed counsel. I'll appoint attorney Jacob Wagner represents you. In the absence of counsel, enter not guilty plea. We'll set a bail review hearing for Friday morning at 8:30. First pretrial will be April the 5th at 1 o'clock. Final pretrial will be April the 19th at 1 o'clock. Trial date will be May the 11th at 8 a.m. Bond will be set in the amount of $7,500 plus your own recognizance, which is your promise to appear. And if you fail to appear, you could be prosecuted for an additional felony. You'll also be required to pay a deposit of $171 prior to release to secure payment of certain statutorily required fees. If you make bond, you'll be under pretrial supervision of the probation department at 117 East Main Street. You report upon release immediately. Let's report to them once a week for 4 weeks, and after that, as they determine, undergo random drug testing they may order. Provide phone numbers for home, cell, and employer. If recommended by probation, you'll be evaluated for substance abuse or mental health issues. If any treatment's indicated, you'll enroll in and follow that during the pendency of this action. You'll also be under house arrest at your residence at 13011 US 50 Bainbridge. It means you have to be there at all times unless you're working, going to and from work, medical appointments, court proceedings in this or any other case, appointments with an attorney or probation officer in this or any other case. You can go to any kind of school, educational programming, classes, etc., church activities. Other than that, you have to be there at all times. If you fail to comply, court could revoke that bond and have you held to a further order of the court. We'll notify your attorney of his appointment, and hearing on your review of your bond will be Friday morning. Have any questions, Mr. Fillmore?
This time, Your Honor. Thank you.
All right, thank you.
Thank you, sir.
Thank you.